There is some urgency involved. We challenge the maintainability of execution proceeding on the ground that the decree has not become executable. That was rejected. Challenging that, we have preferred this. But this appearing as 36. If it is not taken up today, Monday, sometime, maybe kindly fix.
Mr. Banerjee, we have to.
Execution is fixed on Monday.
No upgradation. No upgradation, sorry.
The execution is fixed on Monday. If it is not.
What can be done? Tell the court that your appeal is pending. What else? Who is on your other side?
Mr. Shaunak Ghosh, the matter was, I must be candid, matter was taken up once, I could not appear before your lordship. That is my fault, but
no, don't say it's your fault. That embarrasses us. But please understand, if we give you, if you allow your request for upgradation, how can we deny others? We can't upgrade all matters.
Because of the urgency that
please see, no urgency. Every matter is urgent for that litigant.
We shall pray before the executing court, not informing
that you do. We say nothing. Yes.
Justice Rice, may I mention a matter?
Why do you assume that his lordship will grant leave?
Because, my lord, the matter was disposed of by my lord and Justice Rai Chattopadhyay.
Yes. What do you want?
My lord, the appeal was preferred, challenging an order where...
That bench will be available from Monday, mentioned on Monday. That is the regular bench. Yes.
Wait. May I be permitted to mention one matter for inclusion?
Even before permission you have mentioned. Give it.
My lord, may I take a leave to mention for inclusion, my lord? Earlier, this matter was mentioned, my lord, and the mentioning was allowed by my lord. But when I inquired the department is saying, my lord, that the several requisition has been made to the department, but department is not sending the file, my lord.
Original side, appellate side, what is it?
Original side, my lord.
My lord, this is our original side matter, my lord. My lord directed this matter to be tagged along with the JSUP matter because, my lord, the issue is same. We are challenging NCLT, my lord.
এই করো নিয়ে জেসপের সঙ্গে লাগিয়ে দাও আজকে যদি পারো তুমি আজকে সাপ্লিমেন্টারি বার করে দাও না আজকে 3:30 আছে না today at 3:30 we have listed those JSOP matters so let a supplementary list be published file টা আনিয়ে নাও
লর্ডশিপ দয়া করে অনুমতি দিলে ইন পার্সন একটু প্রার্থনা জানাবো
এক মিনিট ওনার উকিল বাবুরা বলে নিন তারপরে
অ্যাপোলজি লর্ডশিপ
Yes, yes.
My lord, may I have your lordship's kind leave to mention a matter, my lord? Due to extreme urgency, my lord, I am seeking leave to file the appeal without the certified copy.
When was the order passed?
My lord, the order was passed on 22nd April 2025, whereby a receiver was appointed. My lord, it
was passed in your absence?
In your absence, Lord, ex-party order passed.
Without notice to you, or you did not appear?
My lord, it is our submission that no notice was served upon us. Order was passed. My lord, it is only in the month of June that the receiver comes to our premises to take over possession.
Very well. Prayer request allowed. If we find that you were notified but you chose not to appear, something drastic will happen.
Those are my instructions and our pleadings in the petition.
Instructions are often not correct.
Grateful, my lord.
Leave the other.
6 appeals, appellate side.
6 appeals?
Yes, my lord.
Gojo. Receiver in section 9. Section 9.
Yes, my lord. Section 9 of the arbitration. Grateful.
My lord, may I be permitted to mention item number 36 of the non-commercial original side list, my lord?
Non-commercial.
Original side list, lord.
Yes.
My lord,
Pradeep Kumar Das.
my lord, the execution matter is fixed before the learned honorable single judge on 1st of July, lordship, and I will not be given any more time, my lord. So if my lord takes it up on Monday at any time, if lordship fixes...
We just now declined Mr. Ayun Banerjee. Were you not here?
Sorry, my lord, I
Sorry.
was not aware.
Yes. আপনি কি বলবেন?
লর্ডশিপের কাছে একান্ত প্রার্থনা লর্ডশিপ দয়া করে আমাকে যদি লিভ দেবার আদেশ করেন আমি সার্টিফাই কপি দিতে পারিনি লর্ডশিপ ডিপার্টমেন্ট থেকে লিভের জন্য পাঠিয়ে দিলেন
এই কি বলছেন বুঝে নাও উনি বোধহয় অ্যাপিল ফাইল করতে চান আপনি কোনো অ্যাপিল ফাইল করতে চান কি
রেডি হয়ে গেছে আমি জেরক্স সার্টিফাই কপি দিয়েছি অরিজিনালটা পারিনি বলে লিভ চাইছি লর্ডশিপ ভুলবো না
এই
একটু নিয়ে নেবেন কিছু না আছে পাঠিয়ে দেবেন
ওরা ফাইল করলে না, যদি কিছু ফাইল করে কাকু, ঠিক আছে, কি আজকে তো অ্যাপেলেট সাইট, কি কমার্শিয়াল কমার্শিয়ালটা খুলে রেখে দিয়েছি সামনে।
May it please your lordship, this is an appeal under section 37.
Fresh service.
Yes, we have served section 37 appeal against an interim measures under section 15, section 17, unilaterally appointed arbitrator. The clause is the arbitration clause is very strange. It's appearing at page 27. Now, before I proceed, what has happened? Yes. What's happened, my lord?
No, section 17, ex parte order.
Yes.
Go and ask for vacating.
He doesn't even have jurisdiction.
Say so. Challenge his jurisdiction.
Section 16 is pending. It is unilaterally appointed. The clause, kindly see the clause. It's everything is in Calcutta. He has been appointed in Delhi. The jurisdiction would be in Calcutta according to the clause. And kindly see the clause as well. I doubt whether this is at all an arbitration agreement or not.
Which page?
That is page 27. Not only one thing. Yeah, 2 days before we received this letter from the respondents saying that they want to go for conciliation after filing up during the pendency of this appeal.
Yes, so what is your response?
We'll have to take it now after they have invoked how
Everything is possible. You know that. At any stage it can be done.
Yes, we in fact before they invoked, we said my client has got 2 kidney failures. We said, look, please restructure the loan, please reduce the EMI, restructure the loan. They agreed. Then they send the forms on the hardship
পয়সা
forms.
ফেরত দেবে না, এসে কোর্টে বড় গড়া করে করবে, আর করে পয়সা ফেরত দেবে না।
If your lordship wants,
Go
your
for
lordship-
conciliation.
Yes. Yeah,
We have very little sympathy for people who borrow money and they say, oh, reduce EMI, reduce interest rate.
This is a case where he's got
Go for conciliation.
kidney failures. We-
What is the use in keeping this appeal pending?
My lord, then the interim award will go. The interim award will go.
Interim award has been passed.
Sorry, the interim measure.
What interim?
measure.
What interim order has been passed?
Appointment of receiver ex parte and
Very well.
kindly
We will
speak-
say for the time being, receiver to take actual possession. Receiver to take physical possession.
He's to take possession of the movable goods, cots, refrigerators, AC, mobile phones. Page 95 is the order.
Take symbolic possession. You mean mediation?
Yes. Or yeah. The word is used here in conciliation.
Conciliation.
Mediation and conciliation.
Mediation, it will be
Yes.
mediation. Eshoto, affidavit of service filed in court today be kept with the records. Stop in spite of fresh service having been effected on the respondent, comma, as appears from the affidavit of service, comma, nobody appears for the respondent. So, paragraph.
Arbitration.
The appellant challenges an interim order dated March 29, 2025, passed by a learned arbitrator sole arbitrator under section 17 of the Arbitration and Conciliation Act, 1996. Stop. Paragraph. It appears that the appellant borrowed money from the respondent finance company. Stop. Disputes have arisen regarding repayment. Stop. The appellant says that the respondent unilaterally appointed an arbitrator. Stop. Even the purported arbitration clause may not be an arbitration clause in reality. Stop. The appellant's application under section 16 of the 1996 Act challenging the jurisdiction of the arbitrator is pending before the tribunal. Stop. In the meantime, an ex parte interim order has been passed, comma, the operative portion whereof reads as follows. এই মেমোতে করা আছে, মেমোতে অ্যানেক্স করা আছে।
Page 97. চেয়ার টেবিলটা তুলে নিয়ে যেতে বলেছে।
Paragraph. The appellant further says that 2 days ago, where is that letter?
Yes, we have this. Sorry, we should have made a supplementary affidavit. I'm sorry, we should have.
Hey, arbitration act. But Mr. Dashgupta, that was the date, was yesterday, 25th June.
25th June. That we can contact them. We can contact them and ask for. Since the appeal was also pending, we.
কি বললাম?
Commercial Codes Act. Commercial Codes Act within that. Commercial Codes Act.
Section 62. Right. 30 days time.
যাতে পুরো এইসব যত আরবিট্রেশন অ্যাক্ট 2021 এর বই, রিসেন্ট বই কিছু আনো, পুরনো বই দিয়ে হয় না। আর মিডিয়েশন অ্যাক্ট আনবে। Mr. Dashgupta, are you sure that the provision for conciliation still remains?
There has been a, because two acts are showing, I'm a bit confused because, kindly give me one. I'm Mr.
Okay.
Bose, my lord.
So sorry, Mr. Bose. Why don't you come back at 2 p.m. after checking up? Better do that.
Because this provision, the mail chila সাথে এটা 62 number আছে।
Hey, come back at 2 p.m.
I had the latest
Check up also the Mediation Act. এই দুটোর সময় রাখো এটা।
Mediation of 2020. Consideration of mediation.
অর্ডারটা হয়ে যাবে। বিকেলবেলা বলেছি।
I'm led by Mr. Rajdeep Bardhan, Advocate Lordship. Kindly give me a short passover and fix the matter at 12 p.m.
Time for the respondent number.
Lordship, I am appearing on behalf of the Rajdeep Bardhan Advocate,
Behalf of the appellant.
behalf of the appellant.
Yes.
Lordship, kindly fix at 12 p.m.
Fix it at 2 p.m.
12 p.m.
12 p.m. Why?
Lordship, senior is engaged in another matter.
You are here.
I am led by Mr. Arijit Bardhan, Advocate.
You are briefed in the matter.
Yes.
You start. You've got this opportunity of arguing. When were you enrolled?
2022.
22. 3 years. You have been in the profession. Already initiated. What do you want to not today or what? We can't fix it, madam.
Lordship, kindly give me a short passover then.
Allow her to argue. How long? Yes.
I leave it to Malad.
Come.
Malad, I had concluded my opening submissions, Malad.
Patience. Before this bench.
Bench. Then assigned to this bench again.
I see.
Assigned. Malad, I had concluded my opening submissions, Malad. My learned senior friend has also probably concluded.
Oh, Sudeep Dev,
Award,
that award. Just remember, what is the ground of challenge?
Well, there's two grounds of challenge. That award is non-speaking, perverse, bereft of any reasons, and hence tainted with patent illegality. And
You suffered the award.
Yes. And Mullah, the learned judge in the court below does not look into the factum 34.2 at all. So those were my opening submissions, Mullah.
Anyway, yes.
We have prepared a supplementary affidavit.
Supplementary affidavit at this stage.
Yeah.
No, why? Did we grant you leave?
No, Mullah, there's no leave as such.
Because in the paper book, the report of the chartered accountant was not annexed.
That is probably there in the paper book as well.
Only
fact-
4 pages were there, man. And we have annexed the full document. We have also served them an advance copy. We have also served them.
Have they accepted?
They have served, my lord.
Allow them to file. Why shut out? You know. Argue. Complete today. Conclude. You know. Have you filed a written note or something? No.
My lord, we had initially filed it, but we need to revise that, my lord.
We'll grant you time after the conclusion of hearing.
In fact, the only point I had come to opening submissions, that was on the point of the award being bereft of reasons. So Mr. Dev was supposed to argue on that. But if he could overcome the hurdle, then I come back. If couldn't overcome the hurdle, well, I don't come back to rejoin, my lord.
But I need a short passover if that.
Then take this back. এখন অ্যাফিডেভিটটা ফেরত দিয়ে দিন।
Sri, my lord, I appear for the respondent lordship. I'm led by Mr. Siddhartha Banerjee in this matter. This is their section 37. My lord, Mr. Banerjee is traveling outside of Kolkata, lordship. I'm only praying for it to be fixed any other days, subject to convenience of my lords, because he has only 10 minutes of submission left, my lord. Just 10 minutes. Yes, lordship. 10
Sure.
Yes, my lord.
Only on that condition.
Yes, lordship. Only 10 minutes, lordship.
What was the point involved?
My lord, this was, my lord, where the
MAC means?
yes, my lord, section 34 application had been set aside, my lord. I have come up in appeal, and my lord, I had urged that, my lord, the 75% pre-deposit was not made. Therefore, my lord, the section 34 proceedings were a nullity, and my lord, Mr. Banerjee had urged that the issue of jurisdiction was raised, my lord, because the question of supplier is pending. My lord, I have submitted. My lord, I have given my written notes, my lord, with all the judgments.
No. It's been assigned now.
Yes,
Yes,
my lord. My
Lovely.
lord is. Mm.
We'll adjourn it for the day as they are asking. Now, as you know, this is not the regular bench.
Lordship.
From Monday, the regular bench will be back, but we will assemble again either on Tuesday or Wednesday
Lordship.
Yes, my lord.
around 3 p.m. or something like
Lordship.
that.
Yes, my lord.
Right?
My lord, this matter
Well,
is
this
pending
matter
for a
is-
long time. My lord, if lordships will
Next day, lordship, we shall
conclude
conclude.
the
my lord.
hearing and
It's a matter of 25. And you say pending for a long time.
my lord, because my lord, we are agreed.
On the request made by learned junior counsel representing the respondent, comma, let this matter stand adjourned and be listed again when this bench assembles.
I'm deeply obliged, my lord.
শোনো আপনি তো থাকবেন না তোমায় বলে রাখছি because we refer to you as junior counsel.
Not at all, my lord. Not at all.
Grateful, my lord.
Yes, Mr. Das.
Matter was
2008 appeal. You better do it now.
no on that day, the respondent, he did not. Well, kindly goes to the last order.
Order to the file.
He did not have Wakalatnama, then he retired from the brief. Mr. Kaushik Bhattacharya, দে না লাস্ট অর্ডারটা দে না এখান থেকে দে না Now there is no one opposing me.
Yes, but still we'll have to hear the appeal.
Yes. But do it sometime next week.
Why? 2008 appeal?
Could not.
You have got an open goalpost, no opposition.
I know that much. Could not prepare myself. Not well.
Please dispose it of next week.
Yes.
Please dispose it of next week.
Next Thursday.
Read order dated June 17, 2025. Paragraph. Mr. Das, learned advocate for the appellant, seeks accommodation. Stop. List this matter once again. Tuesday.
Wednesday. Next Thursday.
Next Thursday date the other.
কত তারিখে? 3rd July. Thursday তো আগে এগুলো হয় না?
Lord, I am appearing for the respondent in the item number 5 and 6.
ভুল করছেন। আইটেম নাম্বারটা দেখে
Lord, I am for the appellant.
না 238.
Mr. Ghosh, we remember this matter. We had expressed our mind. No. And you said we'll do it another day. Result will be the same.
No result, no result. My Lord has not. I'll argue the matter, my Lord.
Only thing, don't do it today if you can't finish it, because this bench will again not be available from Monday.
My Lord, that apart, my Lord, Justice Rai, for personal difficulty, he may not take up the matter.
Only not today?
Only not till Tuesday. My Lord, next Thursday I have some difficulty. Your Lordship kindly fix it.
It will be there on Tuesday.
Number 6. Baptist Lordship.
Yes.
My Lord, I am for the appellant petition.
Appellant. Oh, right.
My Lord, Mr. Sujoy Bandyopadhyay is appearing for the pro forma respondent. Kindly make it short pass over. He's coming on the way.
Pro forma respondent. Who is for the respondent number 1?
Respondent number 1, as per my direction, my Lord, I have served again, because earlier occasion also we have served. It was stated that left away. Right now it is come back the report that it is insufficient address, but we have served the notice to the address under which the showing the address, they move the application under section 9 before the learned court below. Not only, my Lord, they are suppressed, but also committed fraud before the learned court below, and obtained the order under section 9, which is, my Lord, already stayed by this honorable court.
No, but it says service item delivered to addressee.
Item delivered to sender. Currently, my Lord,
Addressee.
they will have the accepted the earlier one.
Yes, there is service.
But right now they said it was delivered to sender.
Not necessarily. Once again, in May you had served.
Yes.
And that they received the
my Lord, I'm get
notice. March. ঠিক আছে। ওরা সার্ভিস করবে। পালিয়েছে।
অর্ডারটা কোথায় রে? ডিমোটা অ্যানেক্স করেছিস? কোথায় কোথায় কোথায়? না এখানে পুরো এটা আছে, এটা ওদের পিটিশনের পর ইন্টিরিম অর্ডারটা নেই।
What is the date of the impugned order?
ব্যুরো ডেটটা বল। বলা date of the impugned order November 30th, 2018.
Ex parte order.
Ex parte order.
7 years your appeal is pending, and you filed an appeal
Well, this appeal was admitted.
in 2020.
2020, well, delay was condoned, appeal was admitted, and stay has been granted. The 8th order.
Stay of the impugned order.
Yes. Kindly see, my lord, the order dated 19/2/2020, passed by my lord, Honorable Division Bench, Sanjeev Banerjee, as Lordship then was, and my lord Justice Kaushik Chandra. Order number 6. কত নাম্বার পেজ? 24 আছে না? না।
দেখিনি এটা দেখি stay order 19/2/2020. Yes, it's confirmed করে দিই। হুম। We'll confirm the order of stay.
Yes, yes.
Confirm or set aside. We'll set it aside. You can't be affected by that. We'll
No,
set
no,
aside the
no,
impugned order.
no.
এসো এই ফেলে রেখে লাভ নেই 2008-20 appeal.
Set করে দিচ্ছি।
This appeal is directed against an order dated November 30, 2018, passed by the learned third additional district judge, Barasat, in Miss এটা কত 261/18
Miss case number 261
of 18 bracket A and B. ARB arbitration bracket ARB.
ARB.
Comma under section 9 of the Arbitration and Conciliation Act, 1996. Stop. By the order impugned, comma, the learned trial court restrained the respondent numbers 1 and 2 in the section 9 application, bracket lekho. The respondent number 1 is the present appellant. Bracket diye dao. From transferring and oblique or alienating or parting with possession of A schedule, capital A within inverted comma, a scheduled property to any third party till disposal of the application. Stop. Paragraph. Now, the order was passed ex parte. Stop. Paragraph. Being aggrieved, the respondent number 1 before the learned trial court came up with the present appeal. Stop. The appeal was admitted after condonation of delay of about 100 days. Stop. Thereafter, by an order dated February 19, thereafter, delay of 100 days, by an order dated February 19, 2020. Stop. By the same order, a coordinate bench stayed the operation of the impugned order and directed notice to be served on the present respondent number 1, who was the petitioner before the learned trial court. Stop. Paragraph. The appeal has been pending since then. Stop. We find from an affidavit of service affirmed on May 1. Affirmed in May, 2025. Affirmed on May 5, 2025, that notice of this appeal was served on the respondent number 1, served on both the respondents. Stop. However, nobody appears for the respondent number 1. Stop. We further see from the aforesaid order dated February 19, 2020, that the respondent number 1 did not appear before the coordinate bench also.
Yes.
When operation of the impugned order was stayed. Stop. Obviously, the respondent number 1 is not interested in the matter. Paragraph. We find from the impugned ex parte order, that no reason has been recorded by the learned trial court as to why it was necessary to pass an ex parte order of injunction. Stop. It is trite law that an ex parte order of injunction or granting any relief must be supported by cogent reasons, however brief the same may be. Stop. In the absence of reasons, an order becomes arbitrary. Stop. In fact, that is the ground why the coordinate bench stayed operation of the order. Paragraph. In view of the aforesaid, we set aside the order under appeal. Stop. If the application under Section 9 of the 1996 Act is still pending before the learned trial court, the same should be disposed of in accordance with law on an early date upon granting opportunity of hearing to all the parties. Appeal and connected application all disposed of.
Grateful, my lord. I'm deeply obliged.
No, appeal छेड़ा किसी की नहीं.
I'm grateful.
Lord, this is that appeal, my lord, wherein, my lord, with regard to the appointment being challenged and was upheld in my favor.
My lord,
by
I'm
the
appearing
Honorable
for
Trial
the
Court.
I'm appearing for the appellant being led by Mr. Amit Kumar Nag. He is unwell, suffering from viral fever.
Oh,
My lord.
তাহলে এই week-এই নয়।
Kindly keeps it next week, my lord.
Next Thursday or next Tuesday?
Tuesday কি তারিখ? Gives me one more. Tuesday কত তারিখ?
Your junior is
But Tuesday only become.
your junior is looking even thinner today.
He is becoming, my lord, and my lord, ideally the off আছে on আছে।
Later.
He looks ideally like a honorable judge in his younger days. Lordship will just visualize it.
All right. On the request made on behalf of the
She will
appellant,
just visualize it. I have seen him when he comes for a conference in my. He opened it. I was startled seeing him. He looks exactly like him.
all right. On the request made on behalf of the appellant, let this matter stand adjourned and be listed again on Tuesday.
Lordship, if it can be made on Thursday, because Tuesday is not even a week, and if he gets directed with COVID, then it will take some time.
Talk to Mr. Banerjee.
But maybe then the week, my lord.
Tuesday week.
Tuesday week, my lord.
Tuesday week.
Grateful.
Grateful.
You are assisting him in the matter.
Yes, my lord.
You are briefed in the matter.
I'm not properly briefed at the moment right now, my lord.
Very well. What have you done to him? He has fallen ill.
My lord.
No. All right. Next matter.
appeal, my lord.
37 appeal, your lordship.
Yes.
This is my appeal, your lordship. The crux of the matter is that the arbitrator has failed to give any reason in his award, your lordship.
What a reason নেই?
The কিছু reason দিয়েছে, কিছু দেয়নি।
Mr. Sen, the hearing can be concluded today, only then start, because this bench will not be available from Monday.
Yes.
It will.
From Monday onwards, whenever we assemble, we'll assemble only to take up the specially assigned or
I
part of
understand,
matters.
my lord. Then let us keep it next week, my lord. Anyway.
It will take some time, your
It will
lordship.
take some time.
Take some time because I have to go through the award. I have to go through the order.
If there's no reason, what will you go through?
Award where he has not given reason, because it's a journey. Arbitrator reaching a conclusion, it's a journey, it's a sojourn. So how he has traveled the sojourn, that is important. Your
How
lordship.
he has traveled.
How he has traveled
by
and
air,
path
by
he has-
train, by
and his path he has given, whether he has given the path or
He's
not.
aptly learned from his senior. Anirban Rai.
Oh, I see.
How for a state's appeal, one can wade through the turbulent waters.
This is not the regular bench. Stop. On the request made jointly by learned advocates for the parties, let this matter stand adjourned for the day.
My lord, senior is online. He's there.
So, my lord, my comment was not out of the cuff.
Huh?
Yes, side change. My lord, I'm very sorry, my lord. May I just make one request, my lord? My lord, I'm leading Mr. Shanal in this matter, my lord. My lord, I had some problem with my car, my lord. I've not been able to reach, my lord. I'm just an exception, my lord, only for today, my lord. If you could taken up on Tuesday, my lord, or any other day, my lord. I'm very sorry, my lord.
Yes,
I'm still rushing, my lord.
we have adjourned it for the day.
Noted.
I will inform
You have yes, you were present. We have noted.
Only present. I would have.
You are present like Meghnad. We can't see you, but we can hear you.
I'm under all kinds of problems today. Kindly, only for one day.
We have adjourned it.
Oh, I'm grateful. I'm grateful, I'm very grateful. I'm very sorry, I tender my apology, I'm very sorry,
Take care of your car.
I've just been able to get another one now.
এই জন্য খোলেনি, গাড়ি থেকে দেখতে পাবে বলে।
Again, which bench was hearing this?
Both, this bench also heard this.
This bench also heard this. Provided you can complete the hearing today,
This can be good. It's a short.
complete it,
Section
then
8 will not appeal.
very well.
We are only on the question of the plaint being whether the suit should be referred to arbitration or not. Of course, my lord, the maintainability point, which was clarified, I do not know whether.
No, we said that we'll hear
Yes,
on
yes.
the point
Your
of
Lordship, on the last
maintainability
question
also.
said, Lord, Your Lordship will hear out the.
Can you argue that point so that he can respond to it? বলছে ইয়ে, admission. Yes, Mr. Tiwari.
Lord, if Your Lordship will not, can you text, Lord, Chapter 5, Rule 17A first? What is it? Wait now.
17 capital A.
Small A.
Yes, এখানে তো।
That's right.
You had given us.
Yes. Now, my Lord, may I just place 17A says, my Lord, in the case of an appeal from an original decree or an appeal under the Workmen's Compensation Act, or an appeal from an order under Article 226 of the Constitution, an appeal under the Indian Railways Act, an appeal under the Motor Vehicles Act 1988, an appeal preferred under Section 37(1)(b) of the Arbitration and Conciliation Act 1996, thereby setting aside an arbitral award under Section 34 of the said Act. A first appeal against the deemed decree provided in any statute, and in the said deemed decree it is not passed in execution proceedings, admit it, cause it to be registered, and issue notice to the respondent. So, my lord, in these cases, in these appeals, no admission under Order 41 Rule 11 is required, so far as these appeals are concerned. Now, my lord, Your Lordship, my lord, kindly consider, my lord, here says, my lord, 37(1)(b) of the Arbitration and Conciliation Act, thereby setting aside an arbitral award under Section 34. Now, my lord, this amendment came into force. Kindly take a note that previously, my lord, it was operating since 1966. This amendment came into force on 19th of January 2009. But as on 19th of January 2009, 37(1)(b) was appeal challenging the order passed under Section 34, setting aside arbitral award. Now, as on date, 37(1)(b) is equivalent to 37(1)(c). Well, I will be coming to that. As on date, my lord, after my lord amendment, 2015 amendment, 2019 amendment, my lord, as on date, it is 37(1)(c), not 37(1)(b). Now, my lord, I will be placing that. Now, my lord, clause 17A, these are the appeals, my lord, where, my lord, admission is not at all required. So, my lord, an appeal arising out an order passed under section 34 of the Arbitration and Conciliation Act, my lord, admission does not require. Now, my lord, second part. Second part is, in case of an appeal from an appellate decree or appeal from an order other than an appeal under the Workmen Compensation Act, an appeal from an order under Article 226 of the Constitution, an appeal under the Indian Railways Act 1890, an appeal under the Motor Vehicles Act 1988. That means, my lord, these appeals are there in Rule 17A. Now, and so these appeals which are being excluded in 5A, 17A, and my lord, then you will read. And first appeal against the deemed decree passed in execution proceedings. Second appeal, second appeal against the deemed decree. All appeals under Section 39 of the Arbitration Act 1940 and all other appeals under Section 37 of the Arbitration and Conciliation Act, except the appeals preferred under Section 37(1)(b, thereby setting aside an arbitral award under Section 34 of the said Act, admit it, cause it to be registered, and posted to a bench for hearing under Order 41 rule.
সেটা পাওয়ার আমাদের নেই।
Pure simple one.
বিশেষ করে দেখ দুটোকে একসঙ্গে করতে হবে তো 37(1)(b তো এখানেই বলেছে এর বেশি দরকার। So how can we read এখানে যে 37(1)(b দরকার আছে অন্যগুলোর দরকার নেই? একটু কিন্তু কেস আছে। Accepting 37, যেটা এখানে বলে দিয়েছে 37. Correct, he is right. It seems he is right, Mr. Sen.
Let me, I'll kindly.
No. Allow him to complete whatever case law and all.
My understanding of English is very pure. I'm saying very frankly. I had taken the help of AI. What AI is saying, I had taken. My son is studying.
No. We think now you're right. Don't show us AI. We don't like AI.
Kindly consider one thing. I just find out. What on the last occasion, Mr. Sen has said that these are all pre-amendment. Now, till 1966 to 2009, these were operating. Now, in between, there are 5 division bench judgments. All division bench judgment says there is a judgment of Justice Dilip Seth presiding over 37(1)(a) was considered. There is a judgment passed by Justice Chitudor Mukherjee where a deemed degree was considered whether it is admissible required or not. There is a judgment passed Justice Dilip Seth where the divorce decree whether it requires admission or not. Now, considering all these judgments, there is a special bench judgment of Justice Bhaskar Bhattacharya, Justice Altamas Kovid, and another judge. Here also same point came. 3 judges came to a conclusion. All these judgments had been taken into consideration, and thereafter these amendment came into force. But after that amendment also, this only appeal arising out of an order passed under Section 34 of the Arbitration and Conciliation Act. 7 except that appeal, all appeal request admission. And now, what I am saying, 37 now, you will often, Lordship, kindly take Arbitration and Conciliation Act once.
Dismissal of 34
only dismissal of 34 or 30, only my lord appeal arising out of 34, admission does not require.
Sir, will invite admission. Setting aside will not. Will paltano দরকার। Statutory appeal কিসের admission? Matter of right. We need to amend our rules.
Yes, yes, it should be. That should be amended. My lord, this is also, my lord, my responsible submission, my lord, you will also discuss in the administrative meeting, my lord, it should be amended. Otherwise, my lord, kindly have a look, my lord, 37(1)(b). Now, my lord, 37(1)(b) speaks about, the rule speaks about the appeal arising out of an order passed under section 34. Now, my lord, 37(1)(b) is nowadays is granting or refusing to grant any measures under section 9.
No, but
now
this,
it is 37(1)(c).
Correct, correct. You see, this clarifies 37(1)(b), thereby setting aside an arbitral award.
That means, my lord, now it is 37(1)(c). When the amendment, my lord, took place in 2009, it was, my lord, 37(1)(b). Now it is 37(1)(c). So, my lord, it requires, my lord, admission. In my responsible submission, otherwise, my lord, their entire exercise will be, my lord, meaningless.
You want to cite those cases? No, not necessary.
Not necessary, my lord. I can, your lordship, my lord, can you see?
Let me read A first, my lord.
Read, not necessary.
I don't think judgments will be necessary.
Yes, kindly, I am just citing the judgment. First judgment is, my lord, not necessary. Not necessary.
My lordship will kindly see A. In case of an appeal from an original decree, an appeal under Workmen Compensation Act, an appeal from an order under Article 226 of the Constitution, an appeal under Indian Railways Act, an appeal under the Motor Vehicles Act, an appeal preferred under 37(1)(b) of the Arbitration Conciliation Act.
But 1 second.
ডিগ্রি নিয়ে প্রশ্ন অ্যাপিলেবল অর্ডার বলছি আমাদের অ্যাপিলেবল অর্ডার আছে
ওটা কি ওই গ্রাউন্ডে চোখ ছোট্ট করে ডিসমিস তো করতে পারবো টু বি প্লেসড ফর অ্যাডমিশন বিফোর দি এপ্রিল
তার মানেটা এখানে তো বলছো ডিগ্রি এটা আমাদের বুঝতে হবে এবার অর্ডার ইজ আন্ডার দিস order to the
Let us read A, only A first part. In the case of an appeal from an original decree, an appeal under Workmen's Compensation Act, an appeal from an order under Article 226, an appeal under the Railways Act, an appeal under Motor Vehicles Act, an appeal preferred under 37(1)(b) of the Arbitration and Conciliation Act, thereby setting aside an arbitral award under Section 34 of the Act. A first appeal against a deemed decree provided in any statute, if the said decree is not passed in execution proceedings, admit it.
So all these classes, categories, admit it.
Yes,
yes.
That is my case. Now come to B. In case of an appeal from an appellate decree or an appeal from an order, other than an appeal under Workmen's Compensation Act, whatever is provided in A, that is excluded. Other than an appeal under Workmen's Compensation Act, an appeal from an order under the Article 226 of the Constitution, an appeal under Indian Railways Act, an appeal under Motor Vehicles Act, first appeal against deemed decree passed in execution proceedings, second appeal against deemed decree, all appeals under Section 39 of the Arbitration Act 40, all other appeals under Section 37 of the Arbitration and Conciliation Act, except appeals preferred under 37(1)(b), thereby setting aside an arbitral award under Section 34 of the said Act, admit it, cause to be registered.
And then?
And posted to a bench.
For what?
For hearing under Order 41.
That is what he's saying.
No, but admission is not necessary. Well, your lordship will kindly see here what admission is in respect
otherwise doesn't make sense. Clause A makes it clear that an appeal preferred under 37(1)(b as it stood then from an order setting aside an arbitral award.
Yes.
Needs no admission under Order 41, Rule 11. B, read in that light also, B is very clear. All other appeals, excepting 37(1)(b), will be placed before Order 41, Rule 11 bench. We are not dismissing your appeal. It just needs a formal admission because the rules are archaic. Immediately, we need to take up this matter on the administrative
Yes,
side.
then I will not go into that.
No,
Your
don't go
lordship will admit the appeal and
We can't. We don't have the power.
Don't have the power.
Determination.
I see. It is a question of determination.
नहीं तो हमारे Order 41 नहीं.
It should go before the division bench by Justice Bhattacharya.
Justice Bhattacharya. করে দিতে হবে। আমার কোনো সন্দেহ নেই।
Huh?
Like admission as per the Code of Civil, it has to be before Court of Law.
Try to পাঠাচ্ছি।
এসো।
Rule committee. Justice IPM
But this matter, I find, Mala, there is a judgment of Justice I.P. Mukherjee was referred to the rule committee. But this judgment is, your lordship will.
2020.
Admitted মানে এখানে তো Order 41 rule
It has been passed on 2nd of September 2022.
Correct. Not required. No. এটাই তো এখানে বলছি। All other excepting 37(1)(b) required admission.
It মানে registry করে দেবে।
Very well. This is consistent.
সেইখানে।
Hey, এসো। This appeal is directed now against a judgment and order dated March 21, 2025, passed by the learned Court of Civil Judge, bracket Senior Division, bracket closed, Behrampur, Murshidabad, in TS 06/2024.
একই জায়গায় হবে। হ্যাঁ, একদিকে তো ভালোই হবে। Order 41 হ্যাঁ। তো একই একসঙ্গে মেনশন করে।
This is Section 9.
Section 8.
Section 8. This is Section 8.
Section 8 rejected.
কি দেখছি আমি? 21st March 25.
There are by the order 39 rule 1 and 2 has also been disposed of.
Yes, yes.
So one order contains two parts.
I see.
First, the Section 8 has been disposed of, and then on merits order 39 1 and 2. It's a combined composite order.
But inner page 4, first paragraph, you will also get it. Will not Section 8 application was.
Oh, Section 8 was rejected.
Yes.
Yes.
Which Section 8 it was?
My Section 8.
You got Section 8. You are the Zilla Parishad.
Yes. I'm the
You will know. In TS, whereby inter alia, an application filed by the present appellant under Section 8 of the Arbitration and Conciliation Act, 1996 was dismissed. Stop. By the same order, an order of injunction earlier passed has been made absolute in favor of the plaintiff, who is the present respondent, number 1.
1 and 2.
Who are the plaintiffs, Koro? Who are the present respondent numbers 1 and 2? Stop. Paragraph. At the very inception, Mr. Tiwari, learned advocate appearing for the learned senior advocate, case diye debe nahle, appearing for the respondent numbers 1 and 2, says that this appeal requires admission under Section 41, Rule 11.
Order 41.
Order 41, Rule 11 of the Code of Civil Procedure, in view of Rule 17 of chapter 5 of the appellate side rules of this court. Stop. Paragraph. Rule 17. No, Rule 17 of chapter 5 reads as follows.
But can I take your lordship's kind?
Yes, yes, yes.
But just, my lord, only one clarification. Admission is by the registry.
That must be taking on record. Not a very happy language. Because otherwise, we must be just taking on record and placing it before the.
Ultimately, it boils down to hearing has to be by the order 41 bench.
Correct, correct.
Not
Correct.
question of.
Can I ask you rule 17? Yes.
Then the matter, well, your lordship will place it before the appropriate bench.
We will release it from our list and then you mention and get it included. Rule ta dile. Paragraph. We see that clause A of Rule 17 enumerates the categories / classes of appeals which do not require admission under Order 41, Rule 11, CPC. Stop. Clause B of that rule indicates the appeals which require admission under Order 41, Rule 11, CPC. Stop. In our reading of the rule, an appeal under the Arbitration and Conciliation Act 1996, excepting an appeal under section 37 bracket 1 bracket B bracket which is now section 37 1C bracket close. From an order setting aside an arbitral award under section 34 of the Act, requires admission by under Order 41, Rule 11, CPC. Stop. The present appeal is an appeal under the Arbitration and Conciliation Act under section 37 of the Arbitration and Conciliation Act, other than an appeal under section 37(1) capital bracket B, our bracket which is now 37(1)C. Bracket close. Stop. Therefore, this appeal, in our opinion, requires admission under Order 41, Rule 11, CPC. Stop. The case laws are all pre-amendment.
Yes.
Stop. Paragraph. Accordingly, we release this matter accordingly, since we do not have determination to hear admissions of appeal under Order 41, Rule 11, we release this matter from our list. Stop. The parties may take appropriate steps to get this matter listed before the appropriate bench.
Most probably, my lord, another similar matter, my lord, argued by my lord, learned additional special general.
Yes, yes, correct. Thank you, Mr. Tiwari.
Grateful, my lords.
মনে হয় ঠিকই করছে। করতেই হবে তো, ওটা কিসের অ্যাপিল ভুলে গেছি আমি, দেখেছি সেটিং আছে সেকশন 9 সেম। হ্যাঁ,
But item number 2, but that
The
matter,
appellant.
but I was addressing the court, but
On the report of the chartered accountant.
Yes,
My
yes.
learned friend was.
now, but a
Oh,
supplementary.
Mr. Bordhon.
Mr. Bott,
Bordhon is leading me, Your Lordship. Mr. Dev was addressing Your Lordship on the last
but
occasion.
we have prepared a supplementary affidavit, no new document. One particular document was there before the arbitrator, which is the report, which I had handed over to this honorable court, my lord, by of a compilation. But in the report, what I found, which
Mr. Dev, please conclude by 12 o'clock.
very well, very well. Now, my lord, only the annexures, my lord, I have added, which documents are missing, my lord, in the paper book. But that I have placed, my lord, I would address your lordship, my lord, slightly, my lord, on a different point, my lord. I had, my lord, on the last day, my lord, placed your lordship, my lord, the report showing how, my lord, the figure has been arrived at, taking 25% on. Kindly have a look at this, my lord. Maybe lordship is hearing, my lords are hearing after a long time, my lord. There are 3 projects, my lord, Shubhankar, Bhagavati, and Sham Kunj, lordship might recall. Shubhankar, Bhagavati, and
What are you reading?
Sham Kunj, the supplementary affidavit.
Page?
My lord, page, my lord, page 4.
Yes.
Now, my lord, lordship, probably my lords might recall, my lord, while coming to the finding, my lord.
একটু দেখবেন কোনো নোট আছে?
Yes. My lord, while coming to the finding, my lord, lordship might recall, my lord, the learned chartered accountant had categorically held certain documents were not placed before him. He did not have access to all the documents. Only the documents, my lord, which I had, I produced. And lordship might recall, my lord, from the minutes of the meetings held by the learned arbitrator, he had categorically said, my lord, after he had appointed an independent person as a chartered accountant, the appellant herein did not cooperate. In fact, they never appeared. So, whatever documents we could produce on that basis, Millard, he had come to this finding. And how we have calculated, Millard, on the last day I placed before your lordship, relating to the 3 projects. It's a pure mathematical calculation. And this is a fact that the learned arbitrator, while coming to the finding, did not give any independent opinion, independent view. He just referred to the report and accepted. Now, Millard, I had cited on the last day, Millard, 2 judgments. One is, Millard, Associate Builders, and other one is Sangyong. On the point, Millard, the scope of interference, Millard, by the 34 court as well as the 37 court. Even, Millard, the power of interference in Section 37 appeal is limited, Millard. Only, Millard, if there is an error, perversity on the face of it, Millard, and 2 or 3 other things, Millard, as what has been contemplated in the 2 judgments, the interference is permissible in 34. No reappreciation of evidence. And scope is more limited, Millard, when it comes to an appeal under Section 35, because the court does not sit in appeal, Millard. Court only, Millard, sees, Millard, what is there. Reappreciation, Millard, is not permissible. To that effect, Millard, I cited 2 judgments. Now, Millard, one additional judgment I will be citing, Millard, that is, Millard, on adverse inference, Millard. Because the best possible evidence,
Yes.
My lord, that is, my lord, AIR 1981 Supreme Court 997.
Very well.
Because the best possible documents they had, they were in control. They were the main partner. Actually, the project was, my lord, there are 3 projects for construction of a property. There are 8 partners. All of them got their share of profit. Only my client was left out. That is his grievance as a pure monetary claim. So kindly have a look at this judgment. My lord, I'm not placing the judgment in its entirety, my lord. What had happened here, my lord, a suit was filed, my lord. It was decreed, reversed in appeal court, first appellate court. Matter went to the Supreme Court reversed it. And my lord, the question arose, my lord, how far, my lord, section 114 of the Evidence Act can be stretched. Now, my lord, straightway lordship would kindly comes to paragraph 10. I'm not troubling your lordship with the facts. Paragraph 10, my lord. Paragraph 7, it talks about the view of the High Court. On what points Honorable High Court had decided. Then, my lord, in detail, it discussed also the issues involved in the appeal. One of the issue is about withholding the document. That lordship would find, my lord, in page 979, because certain documents were not placed withheld. And the important observation is paragraph 10, my lord. May I, my lord, place it? If the case propounded by the defendant firm at the trial is correct, its account books must be containing entries to the effect that the agreement of purchase of 225 bags of tobacco was entered into with the firm R.K. Patel and not with the plaintiff, and that sometime in December 1995, the account of firm R.K. Patel was credited with the account of price of the goods. Entries would further be available therein indicating unmistakably the periods for which so-and-so was admittedly employed with the defendant firm. The non-production of those books by the defendant firm and the production of those books by the defendant firm and the production by it of stray letters and the bill constitute failure on its part to produce the best evidence, and the presumption has therefore to be raised against it. If such evidence has been produced, the same would have gone against the case propounded by it. The matter does not end there. The failure on the defendant firm to bring Chota Bhai and so, my lord, into the witness box and the fact that it made no attempt to have the accounts of books of firm R.K. Patel, the entries in which account would perhaps have clinched the matter in dispute, must be similarly construed, and a presumption drawn this evidence also would be gone against the defendant firm. And finally, my lord, the Supreme Court, my lord, set aside the order of the High Court, my lord, on this ground. If you have the best possible documents in your custody, in order to assist it, it's your responsibility to produce before a court of law so that the justice can be rendered. If you don't produce it, certainly, my lord, 114 of the Evidence Act will come into play and the adverse inference, my lord, should be drawn. This is on the merits of the case. Now, my lord, I'm slightly, my lord, deviating from the issue. 19/81, Supreme Court 971. 97. Right. Now, my lord, supposing, my lord, the courts are not with me on this point. Whether, my lord, there is a possibility of remand or not on this limited issue, eliminating the scope of Section 34, because the appeal is the continuation of proceeding. Section 34, then the appeal. Now, if Lordship sees, my lord, the Section 34 of the Act once, it was previously an application in writing was required to be made for remand. Kindly have a look at this. This is my alternative argument. Otherwise, my lord, if this goes, my lord, again I have to go back and proceed.
You have filed a written note, no?
Yes, I did, my lord, but I have not taken this point. I have taken the other points. I have filed a written note referring to the two judgments.
You better take it back and file a fresh one with all points.
Very well. Well, only thing I would, Milord, if Lordship permits me to place this case once, because by 12 I would be able to conclude. Then on the next day I can come up with the written notes, and my learned friend can also.
We will grant you time because they also want to file a fresh written note.
No, judgment, Milord, if I cite, then they can get hold of it, and on the next
No,
day.
we can hear you even after 12.
No, Milord, Lordship has said, Milord.
No, we have no problem.
Very well.
You conclude your oral argument today.
Very well.
Then file whatever note you want
Absolutely,
to file.
absolutely. Now, Milord, kindly have a look at this, because that's an important thing, Milord, I found, Milord. Kindly have a look at, Milord, section 34 once, Milord. Judgment কোথায় গেল? Section 34, Milord. 4. On receipt of an Lordships have got it, Milord. On receipt of an application under subsection 1, the court may, where it is appropriate and if it is so requested by a party, adjourn the proceedings for a period of time determined by it in the order to give the arbitral tribunal an opportunity to resume the arbitral proceedings, or to take such other action as, in the opinion of the arbitral tribunal, will eliminate the grounds for setting aside the arbitral award. Milord, in writing, prior to this judgment, Milord, it was a necessity, and it should have been made because before the 34 court. Admittedly, Milord, 34 court held in my favor, upheld the order, upheld the arbitral award. So there was no scope. Now at the 37th stage, supposing, Milord, supposing the court thinks the award is not correct, can the court, Milord, remand it back to the learned arbitrator only on a sole limited point about the accounts? Now, Honorable Supreme Court, by a 5 judges bench, held in writing is not required, and that is permissible in section 37 also. May I, my lord, cite that judgment? Because we have to see an end to this litigation. Otherwise, if the court is not with me, then again I have to give a section 21 notice, again section 11, think about the predicaments of a client, and also think that the non-cooperation made by the other side, admitted position, can't be controverted, that when the learned arbitrator requested on up to a number of times, please produce the documents, he did not appear.
So why is this remand contemplated? To enable the arbitral tribunal to eliminate the grounds for setting aside.
Lordship.
Therefore, we will have to come to a conclusion that there are good grounds for setting aside.
Absolutely.
Therefore, we are remanding it to grant an opportunity to the tribunal to eliminate those grounds.
Absolutely, my lord. That's an alternative argument. My first argument is there is no scope. This is my alternative.
No, we have followed.
My lord, kindly have a look at this judgment once, my lord.
This is a very recent one, no?
Yes. Justice Sanjeev Khanna, my lord, the Honorable Chief Justice has.
Regarding modification of the award.
Yes, absolutely, my lord. Absolutely. On reference, this was decided, my lord. Lordship, my lord, probably knows, my lord. As Chief Justice of India, he deliberated, my lord. এটা তো এখনো রিপোর্টেড হয়নি, বুঝলি আন্টি। এটা হচ্ছে গায়ত্রী বালাস্বামী ভার্সেস মেসেস আইএসজি নোভাসফট টেকনোলজিস লিমিটেড। চন্দ্রচূড় না, জাস্টিস খান্না। My lord, kindly comes to paragraph 55 onwards, my lord. Lordship can note the paragraphs, my lord. paragraph 55 to 62, 63 to 65 on this issue. And reference was on certain issues. At first page, Lordship would find, I'm sorry, my lord.
Paragraph 55.
Paragraph 55 onwards, precisely paragraph 57.
As elucidated above.
My lord, paragraph 55 starts with section 34 2B enables the awards to be set aside. Lordships are not getting it, my lord. My lord, it has been paginated. Page number is at the bottom. Page 46.
Page 46. না অন্য কিছু না অন্য কিছু না এই দুটো দিয়েছে
দুটো
এটার হবে
কটা কপি দিয়ে
পেজ 46
না না দশ
ইয়েস
মানে কোন প্যারাটা ছিল এটা প্যারাগ্রাফ হ্যাঁ প্যারাগ্রাফ 56 মিনিট if I may place it মিনিট 56 onwards বার করো তো observation
yes
page 47
yeah.
may I মিনিট Section 34(2) is significant since it permits patent illegality appearing on the face of the award as a ground to set aside the award for domestic arbitrations and does not extend the said ground for international commercial arbitrations. The proviso appended clarifies the award was not to be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Then, paragraph 57. Section 34(4) is a very significant section which came into considerable deliberation at the hearing. Under this provision, a safety valve is provided to prevent awards for being set aside by the Section 34 Code by providing an opportunity to the arbitral tribunal to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the award. This section has come in for judicial interpretation and will be discussed later in the course of this judgment. Then, one other section which ought to be referred to is section 43(4), which deals with the situation post setting aside the award. Section 43(4) has been quoted. Then, paragraph 59. The overarching note of the restraint in judicial intervention as set out in section 5. The prescription for intervention set out in section 13(5) and section 16(5). The range of opinions under section 33 of the parties and the arbitrators to carry out repairs to the award in the matter set out therein, the limited opinion to seek recourse to set aside on prescribed grounds which shackle only if in the section 34(2) and further safety valve available under section 34(2) go book to the arbitrator under circumstances mentioned therein are clear pointers about the actually circumscribed nature of the power under section 34. This viewed in the background of the fact the parties have an open eyes contracted to go to arbitration and subject themselves to the parameters prescribed in the act after ousting the normal judicial process clearly indicates that parties were conscious of the limited role of the courts in the review of the arbitral tribunal, the absence of express powers to modify for a court hearing of the objections against the award when such a power has existed in the precursor. Our act also points out the legislative intent. It is in this background that the arguments of the parties clamoring for a reading in of the power of modification needs to be tested. Then a 7-judge decision, 7-judge bench, my lord, that has been referred to. Now, my lord, kindly, my lord, comes to the relevant portion which talks about section 37, my lord. Just give me a moment's time, my lord. I would paste that paragraph, my lord. May I, my lord, just
you find out
lot. ওই প্যারাটা কোথায় গেল উপরে প্যারা 62
Yes, which paragraph next?
But I'm sorry, my lord, I made a mistake initially. There are two judgments I found.
Yes.
The lordship read the correct one, my lord, which started with the word that elucidated above. That was the right one. And I made a mistake. I read the subsequent one and didn't get the proper paragraph. My lord. Sorry, my lord. I'm sorry. Page 24 or page 61. This is just because the two judgments have been, my lord, annexed. I'm sorry, my lord.
ভেঙে ফেলছে কি ভেঙে ফেলছে সবকিছু পেজ 20
page 24 issue to modify or to remit address may I, my lord. Paragraph 55. As elucidated above, if a fog or uncertainty obscures the exercise of modification powers, the court must not modify the award. Instead, they should avail their remedial power and remand the award to the tribunal under section 34(4). Under the subsection, either party, whether the one challenging the award under section 34 or the one defending against such a challenge, may request the court to adjourn the proceeding for a specified period. If the court deems it appropriate, it may grant such an adjournment, allowing the arbitral tribunal to resume proceedings or to take necessary corrective measures to eliminate the ground for setting aside the award. Thus, Section 34(4) provides a second opportunity for a party to seek recourse through the arbitral channel. However, the power of remand permits the court only to send the award to the tribunal for reconsideration of specific aspects. It is not an open-ended process, rather it is a limited power confined to or limited circumstances and issues identified by the court. Upon remand, the arbitral tribunal may proceed in a manner warranted by the situation, including recording the additional evidence, affording a party an opportunity to present its case if previously denied, or taking any other corrective measures necessary to cure the defect. In contrast, the exercise of modification power does not allow for such flexibility. Courts must act with certainty when modifying an award, like a sculpture walking with a chisel needing precision and exactitude. Therefore, the argument that remand powers make modification unnecessary is misconceived. They are distinct powers and are to be exercised differently. Section 34(4) next paragraph, my lord, derived from the model law is discretionary in nature. This is evident from the use of the word may in the provision. The court may invoke this power when it identifies a defect in the award that could lead to its setting aside. In such a case, the court may seek to prevent this outcome by granting the arbitral tribunal opportunity to rectify the defect. While it is not appropriate to establish rigid parameters or a straitjacket formula for the exercise of this power, it is clear that Section 34(4) does not authorize arbitral tribunal to rewrite the award on merits or to set aside. Rather, it serves as a curative mechanism available to the tribunal when permitted by the court. The primary objective is to preserve the award if the identified defect can be cured, thereby avoiding the need to set aside the award. Accordingly, a court may not grant a remand when the defect in the award is inherently irreparable. That, my lord, the court has to decide. A key consideration is the proportionality between the harm caused by the defect and the means available, my lord, to remedy it. That is, my lord, important. 59, while exercising this power, the court must also remain mindful that the arbitral tribunal has already rendered its decision if the award suffers from serious acts of omission, commission, substantial injustice, or patent illegality. The same may not be remedied through an order of remand. Clearly, there cannot be a lack of confidence in the tribunal's ability to come to a fair and balanced decision when an order of remit is passed. Thus, an order of remand should not be passed when such order would place the arbitral tribunal in an invidious or embarrassing position. Additionally, remand may be inappropriate when it does not serve the interest of the parties, particularly in time-sensitive matters, or where it would lead to undue costs and inefficiencies. Once an order of remand is granted, the arbitral tribunal has the authority to vary, correct, review, add to, or modify the award. Notably, under Section 34(4), the tribunal's power through confined remain nonetheless substantial. This stands in contrast to the court's narrow rule under the rest of the Section 34. Then the court referred to the Kinnori Molli, where it has been said that in writing, it has to be done in writing. rendered to and laid down the preconditions for exercising the power of remand under section 34(4). It held that the court cannot exercise the power of remand suo motu in absence of a written request by one of the parties. Secondly, once an application under section 34(1) has been decided, the award set aside, the court becomes functus officio. It cannot thereafter remand the matter to the arbitral tribunal. Consequently, the power under section 34(4) cannot be invoked after the court has disposed of the section 34(1) application. We are then, my lord, the difference, my lord, and the court's views. We are unable to accept the view taken in Kinnori Mollik Supra, which insists an application or a request under section 34(4) must be made by a party in writing. The request may be oral. Nevertheless, there should be a request which is recorded by the court. We are also unable to agree that the request must be exercised before the application under section 34(1) is decided. It's a point of elimination. Section 37 annexure permits an appeal against an order setting aside or refusing to set aside an arbitral award under section 34. To this extent, the appellate jurisdiction under section 37 is coterminous with and as broad as the jurisdiction of the court deciding objections under section 34. Hence, the contention that the tribunal becomes functus officio after the award is set aside is misplaced. The section 37 court still possesses the power of remand stipulated in section 34(4). Of course, the appellate court, while exercising the power under section 37, should be mindful whether award has been upheld by the section 34 court, but the section 37 court still possesses the jurisdiction to remand the matter to the arbitral tribunal. Then this is the basic thing which differed from Kironi Mollik and came to its independent view. So if the court fails there the issue is purely on accounts and the documents, whatever available, he proceeded and kindly see the conduct. If the court is not with me, instead of again going back, whether this can be remanded. That's my alternative argument. These are all my respectful submissions. I'm not placing the facts because already I've shown the 25%.
Yes,
so I'm not placing it on.
No.
I'm grateful.
Yes, Mr. Bardhan, anything in reply?
My lord,
You will file a written reply?
my lord, but I had initially argued, my lord, only on the point of patent illegality. Insofar as I said that the award was non-speaking, it was bereft of reasons. And my lord, section 34(2)(a) had not been considered by the section 34 court. And it's very, in fact, the section 34 court.
What is 2A patent illegality?
Yes, my lord. Kindly, my lord, I'll place the relevant portion of the judgment. That would kindly see, my lord, page 217. This would be the volume 2 of the paper book, my lord.
For 2B?
2A. 2A. 4.16.
Yes.
Let's see, the examination of the award passed by the learned arbitrator, as well as the report of the chartered accountant by this court, has been done for the limited purpose of arriving at a conclusion to satisfy as to the conditions of section 34(2)(b) of the Arbitration and Conciliation Act, the non-registration of the partnership deed, and it goes on, my lord. 34(2)(a), 34(2)(a), my lord, deals with an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. So, this aspect had not been gone into, my lord, by the section 34 court. And, my lord, which I say, my lord, therefore, the award ought to have been set aside on the ground of patent illegality. And this jurisdiction of the section 34 court was not exercised by section 34 court. So the section 34, the judgment passed by the section 34 court is also flawed. These were my opening submissions. So far, I had two other points saying that there were 3 agreements. So there had to be 3 references. There was a composite reference. 1 award. 3 agreements. 3 agreements containing 3 arbitration clauses. And there's 1 award. That would be my other point. And my lord, the other one was both the tribunal, the arbitrary tribunal, as well as the Section 34 court proceeded on the expert evidence without, my lord, assessing the same and placing sole reliance thereupon. So those would be other 2 points.
Very well. You file your written note, indicate very short notes. Please don't make it verbose and long, you know. How long? 1 week, 2 weeks? 1 week.
1 week. We'll meet with his
And
points.
we will be relying on all the judgments that we referred to.
Yes, please annex the judgments. If you want, don't take away judgments from our...
No, my lord.
Because we have marked these.
Since I have already filed written notes, I will file it separately containing all points and annexing the judgment.
Then you
which I
take
have
this
referred.
back.
We can both take it.
No, it will confuse us.
Very well.
We'll take it back, my lord.
Yeah, take back your respective written notes. বুঝেছেন ফেরত দিয়ে দিন ওরা নতুন করে ফাইল করবে
And also
hearing is concluded for all practical purposes. Paragraph, learned counsel for the parties seek leave to file short written notes of arguments
and the judgments relying thereupon,
along with copies of judgments relied upon by them. Paragraph, let such notes be filed.
Let him not cite any new judgment. Otherwise, I have to deal
the point
with that.
The point is, when I had made my opening submissions,
I will not get any opportunity to deal with the judgment.
When I had cited my opening submissions, my lord, it was only on the point of law. I did not cite any judgments. But those judgments had to be relied upon, my lord, to buttress.
Otherwise, I will not be able to.
Then I can supply the judgments, my lord. That I can do.
Deal with the judgments.
Very well. On the next day, when you come back, you can deal with those judgments.
Give me the references.
So, argument limited to that extent on the next date.
Sure.
কি বলছি?
No problem.
Within filed by আজকে কত তারিখ? 26th. June 3, July 3. Stop. The citations of the decisions which the appellants wish to rely upon shall be made available to learned advocate on record for the respondents by tomorrow.
Only one respondent, others are not.
Oh, respondent. By tomorrow. Stop. On the next date, comma. Oral argument will be restricted to learned senior counsel for the respondent dealing with such cases. List this matter on July 3.
But I am appearing on behalf of respondent number 1 only because there are other respondents. They are not appearing.
Respondent number 1. No, it is specially assigned.
Taken back the notes.
Thursday, of course. ওটা তো 5 মিনিট ওটা তো any day.
July.
This is a specially assigned. So possibly Wednesday or Thursday we are.
When it is convened to this court.
July 3. Can you make it better? 2nd July? No.
Absolutely.
No, he cannot. Very well. It's your birthday. Ranchi.
At this age, you will go to Ranchi?
Yes.
Not the right time.
No, yes, we need to.
Third.
Wherever the mullah becomes us, we have to travel.
তুমি বলে দিও একে কৌশিকের থার্ডেতেই আমাদের একটা বেঞ্চ নিয়ে আমার সঙ্গে যেন কথা বলে নেয়।
Grateful, brother.
I'm so grateful.
I appear for the appellant. Lordship will recall this is that appeal where the Section 9 court had disposed our Section 9 application along with the interim press on the ground that the arbitral tribunal was appointed by the Section 11 court. The Lordship was pleased to grant us the same protection initially, and on the last occasion when the railway authorities had not appeared, Lordship had asked us to serve them a notice and come back.
No, again, the problem is now today we have delivered written an order that this will require admission under Order 41 Rule 11.
heard that. We have an innocuous prayer, my lords. That is, on 17th of June, the arbitral tribunal has entered reference.
Sir, do you understand what we are saying?
Then
My lord,
lordship,
I'm leading him, my lord. If your lordship kindly permits me, my lord.
I heard that judgment, lordship. Then we'll.
My lord, we'll just go through your lordship's judgment and come back, my lord. Then, my lord.
Come back.
I'll just brief my senior on that also.
Come back.
Being a statutory appeal, my lord, I'll just look into the judgment, my lord. I'm very grateful, my lord.
Look at Rule 17. It needs to be amended, Mr. Roy.
But I'll just look into it, my lord, and my lord, I'll come back.
Archaic.
By the interim order, my lord.
It's till 30th of June, end of June. My protection would go, my lords.
We cannot before admission.
Then my lord kindly keeps it on Monday, my lord. If your lordship kindly keeps it on Monday, then.
Yes, Monday. Not today.
My lord, I'm grateful. Grateful, my lord.
On his legs, my lord.
Judgment pass Monday. We'll come back on Monday, man.
Come back on Monday.
Very grateful, man. Grateful.
I appear for the appellant, my lord. My suit was dismissed on the very first day, my lord. In a commercial court, my lord, I filed a suit praying for recovery of money with urgent interim release whether the properties are being sold. Amendments made in the plaint. The court below held that since there is no separate application, so first, since there is no separate application for exemption under Section 12A, and so this is one ground when the court held that.
On that ground, it was.
And the court held that there is no relief claimed in the prayers of the plaint, which again incorrect, nor there is any pleading, which is also factually incorrect, my lord. May I show, my lord, the pleadings and the impugned order, my lord?
So this was at the ex parte stage.
Yes, first day, my lord. My lord takes the impugned order, my lord. Or may I show the plaint first, my lord?
No, let us see the impugned order.
Very well. My lord takes last paragraph of page 4 onwards, my lord. The judgments are discussed and then page 4, last paragraph onwards, my lord, is defined.
Is plained?
Yes, my lord. Page 42 onwards. My lord. The relevant pleadings would appear at paragraph 15 onwards, my lord.
প্রেয়ারেও তো আছে 22 তো নোট করেছে অর্ডারে মানে ইমপিউন্ড অর্ডারে হ্যাঁ সেই থাকলেই হলো আমরা এক কাজ করি চেষ্টা তো করবোই করে কি করবো গ্রান্ট করে দেবো না ফেরত পাঠিয়ে দেবো? We'll set it aside.
My lord will kindly do that. My lord. It's law is very well settled.
Send it back. Send it back.
Yes, my lord.
Hey. This appeal is directed against an order dated January 9, 2025, passed by the learned judge, commercial court at Alipur, in MS /com 171/2024, whereby the learned judge rejected the plaintiff's plaint. Rejected the plaint of this suit filed by the present appellant. Stop. The ground on which the learned judge rejected the plaint is the primary ground, is that the appellant / plaintiff has not prayed for dispensation of the requirement of pre-suit mediation contemplated in section 12 capital A of the Commercial Courts Act, 2015. Stop. Paragraph. We have gone through the order impugned. Stop. We have read the plaint. Stop. Not only the plaintiff has pleaded its case under section 12 capital A of the Commercial Courts Act in paragraph 22 of the plaint, the prayers in the plaint also include a prayer for leave under section 12 capital A of the Commercial Courts Act. Stop. Paragraph. Hence, it is obvious that the learned trial court did not apply its mind properly and did not appreciate the pleadings in the plaint. Stop. On that ground alone, we set aside the order under appeal. Stop. The matter is remanded to the learned trial court for fresh consideration.
Will my lord grant leave here itself, my lord, because
Not problem. Go. Disposed of. না respondent to the expertise হয়েছিল প্রথম দিনেই উড়িয়ে দিয়েছে Any corrected application is there?
This the can one was there, my lord, only.
Very well. Both disposed of.
I'm deeply obliged.
For hearing item number 4.
My lord,
Statutory right.
my lord, my lord, my lord, on request
This
of
is
my
that
lord,
matter.
learned, my lord, government pleader and my lord, Miss Noel Banerjee, my lord, kindly, my lord, one day accommodation, my lord, they are both informed me, my lord, to request your lordships, my lord, one day accommodation, Monday, my lord, we will
This is that
complete, my
matter where
lord.
the
This is
people-
this exact submission you've been making every day.
My lord, what can I do, my lord? My leader, two
What
leaders,
can you
my
do?
lord.
What?
My lord, my lord.
How long have you put in now? Tell us.
Monday, my lord, if my lord, they
How
failed, my lord.
long you have put in? How long have you been practicing in the High Court?
2011.
11, 14 years.
My lord.
10 years is the requirement for becoming a judge or for senior gown.
But definitely, my lord, if
So
my lord,
you will argue it.
one day, my lord, they failed,
Next
my lord.
day, sir,
My
next
lord,
day,
my lord, my lord, definitely.
no adjournment,
My lord,
whether your seniors are in Calcutta or elsewhere.
my lord, definitely.
You will have
I assured, my lord, I assured, my lord, I argue. Your lordships, my lord.
This is that matter that paperwork after lordship.
Again adjournment. Again adjournment is sought for on behalf of the appellant. Stop. As a last opportunity, comma, let this matter stand adjourned for the day. Stop. Mr. Comma, learned advocate assures us that on the next date, even if his seniors are not available, comma, he is going to argue the matter.
Lordship.
You have got 3 days holiday.
Only
Spend
one.
all your time reading that brief.
Only one request. Since appellate side will be taken up on Tuesday.
Yes.
1st July is fine, but 3rd July I have a difficulty. 1st July it is.
1st July.
Yes. Because Monday it is not going to be taken up.
Monday very unlikely.
Yes. Tuesday is yes.
তো 1st July তো হবে।
Yes, yes. High level.
অটোমেটিক্যালি 1st July হবে তো। Not today তো করলাম। কি? Adjourn for the day মানে 1st July। মানে শুনুন সোমবারও লিস্টে থাকবে।
Number 5 and 6.
I've been led by Mr.
On his undertaking to argue the matter himself, if his leaders are even if his leaders are not available.
If I am there, I can't force him to.
Why?
State matter. Your lordship knows the pressure, my lord.
We are forcing him not to.
But only one thing was that a really academic issue, my lord, that is, my lord, the word admission is creating the confusion, my lord. The language of both these provisions, the only difference is hearing has to be under Order 41, Rule 11. Both A and B say admit, but admission is not never by court, as per that rule.
That admit, the word used in B, clause B, must be meaning is taken on record.
Even
Otherwise,
in A, my lord, even in A, that admit is there. A has also admit, and the main provision starts with the procedure before the registrar. So admission up to admit it, my lord, is same for A and B.
This is all very confusing. Therefore, we need to immediately change that rule. In any event, 37(1)B has to be substituted by 37(1)C.
That has to be done.
Yes.
And it has to be heard under Order 41, Rule 11.
Correct. Correct.
If it is the objection is as to the
Heard for admission. Again, for what? Heard for what?
For hearing. Because that admission is common for A and B. Only difference in B is and post it for hearing under order 41.
When there is a question of admission, an element of discretion comes in, whether the appeal will be admitted or not at all.
But that
Hearing the admission. The hearing under order 41, rule 11, as my brother points out, is only hearing for the admission.
but I did not. Order 41, rule 11 says about procedure of the appeal.
No, it says appellate court after rule 1.
Yes.
Order 40, rule 11, sub rule 1.
Sub rule 1.
The appellate court, after fixing a day for hearing the appellant or his pleader and hearing him accordingly, if he appears on that day, may dismiss the appeal.
Yes. So that's a procedure of hearing.
What?
Of hearing.
For what? Either admit or not admit, dismiss. Not on merits. Whether it merits admission, what are the points of law?
Because it says may dismiss the appeal.
If it is not dismissed under Rule 11, then Rule 12, day for hearing appeal.
So that admission is inferred there.
Yes.
Inferred there. Yes.
And it's only on hearing the appellate. The respondent has no right of audience there. Order 41, rule 11.
Yes, yes. That is true. But I wanted to clarify this.
My Lord, I am appearing for the respondent, my Lord. A learned senior counsel from Delhi, Mr. Markanda, was appearing, but suddenly due to some health issue, he had to discontinue and leave the meeting. My Lord, I am praying for 1 week's time for him to appear, and in the meanwhile, we'll file the written notes of arguments. They are also pending to be filed.
Whoever argues the matter on behalf of the respondent, please request him to be physically present here. It is very difficult to have virtual hearing. Our connectivity is not so good. We have to adjourn for a
In that case, my Lord, a little more time may be given so that arrangements can be made.
We'll give you 2 weeks time. 5-6 একসঙ্গেই হচ্ছিল দেখে নিও. It is submitted on behalf of the respondent that learned senior counsel who was representing the respondent he has retired from the matter. He has retired from the matter.
No, my Lord, he is appearing. It will be his first appearance in this matter. Before final written notes of argument was directed to be filed, my Lord, and the paper books weren't served.
You say there's some health issue.
Right now, my Lord. Yes, he was there.
Learned senior counsel, কি বললাম? Representing the respondent. No, who na? No. Who was কেটে দাও? Representing the respondent is indisposed. Stop. He seeks accommodation. Stop. Paragraph. Let this matter be listed again. A fortnight hence. Date দিয়ে দাও. Stop. On that day, on or before that date, written notes of submission shall be filed. You have already filed by the parties. We are not recording it, but request him to, whoever argues, request him to come and argue.
I'll pass this.
Judgment to compilation ready হয় না।
That's no fun. Although it's fun idea, but that's no fun.
Fun idea. Then
Fun
I'll
idea.
come back on Monday ভেতর হয়ে যাবে। I'll come back on Monday.
ঠিক দেখে নি না না সোমবার হয়ে যাবে সোমবার মানে so far the judgments which Mr. That wants to rely upon, may I be favored with the judgment
Yes,
so that I can
better he can come
get
ready.
ready? Yes.
He's normally ready with all judgments.
Yes. So that
He's always ready.
No. I'm the respondent. I know Mr. That will start.
And he has never ever, whenever he's never ever said that I have cited a judgment on point. He never agrees with it. But Miller, that is what.
Very well.
If the party
Happy Rath Yatra.
compilation
আর ওকে একটা copy দিই।
I get ready. Mr. Ganguly will do it.
Obliged.
দুটোই 7 and 8.
Yeah, 7 and 8. সোমবার.
Appealing for the respondent, Lordship. This will be the 7th adjournment they will see.
This is impossible. একবার dismiss করে দিই তারপর আসবে। এই একবার call the entire list once.
I appear for the appellant. Well, this is that matter with regard to mean profit. Well, the special referee had
Pass it
calculated.
over.
Your Lordship, Mr. Dhruvo Ghosh appears for the appellant in this matter, Your Lordship. I was praying that the matter be kept any day after next Wednesday, Your Lordship.
On the request made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on এটা কি original side. ঠিক আছে, লিস্টে June 3, Thursday.
July.
Yes, of course.
Grateful, Your Lordship.
My lord, humbly praying for item number 11, my lord. I'm appearing on behalf of the respondent, my lord. Can this matter be taken up at 2 p.m., my lord?
We have passed it over, madam. Dakho.
Grateful, madam.
13 क्यों नहीं?
13 Lordship, I am appearing for the appellant Lordship, if I may be allowed to appear online Lordship.
It's not very convenient, our connectivity is not so good.
Lordship, I apologize, Lordship. I was just seeking, Lordship. This is the matter where learned senior counsel Mr. Jishnu Shah is appearing, Lordship. And this matter was substantially heard before your Lordship, along with Justice Rai Chattopadhyay, Lordship.
Very well, then not today. From Monday, we have that bench again.
Lordship, on the next week, Mr. Shah will not be there. So I was just beseeching your Lordship if the matter can be taken up on 7th of July, Lordship, subject to convenience.
এটা প্রথমে বলে দিলে কত সুবিধা হতো। On the request made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on July 7.
Grateful, your Lordship.
Your Lordship, in this matter, I'm appearing for one of the respondents.
Pass over.
Lordship, I am appearing on behalf of the UCO Bank. I have been asked to appear in the matter, Your Lordship.
But I am appearing for the respondent in this matter. This is an appeal.
The appellant is not here, Mr. Ghosh. Pass it over.
Kindly grant us a date because I am not a party to the appeal. Lordship had directed me to appear. That is why I have appeared. I have
We have directed.
this
No.
Court. So what my learned friend wants is a specific date because otherwise,
In the second call, if they are not here, we'll dismiss it.
kindly appreciate I'm not a party in the matter.
Dakho. Next.
I 26, Your Lordship, I am appearing on behalf of the appellant. Lordship, today the respondents are not there. We filed our paper books with the department. We've served upon them. It's ready for hearing.
If you want in the second call, we can take it up. or we can adjourn it, whatever you want.
Your Lordship, Mr. Kankani is leading me in this matter. Avinash Kankani. He's not well today, so Your Lordship, let it
Very well.
stand over next week.
26 Teleco. It is submitted on behalf of the appellant that learned arguing counsel for the appellant is indisposed. Stop. As requested, comma, let this matter stand adjourned.
Next week, any day convenient for Your Lordship.
Adjourned for the day. Adjourned for the day. Stand adjourned for the day. Yes. Ejo. Didi, dismiss for default. Usual order, জানে তো? Give your appearance.
My lord, I appear for the appellant.
My lord, I am appearing for the.
Yes, you were saying something.
Yes, my lord. This is that matter with regard to the special
Main profits.
Yes, my lord. We had concluded our submissions. They were supposed to rejoin today, my lord.
Who is appealing for you?
My lord, Mr. Sabyasachi Chaudhary.
Yes, yes.
My
What do you want?
My lord, can
Not
this matter
today.
be taken up at 2 p.m., my lord?
No,
My lord, humbly pray.
not today.
Grateful, my lord.
One second. এটা কি, was this bench hearing that matter?
Oh, my lord, on the last occasion, my lord, Honorable Justice Rai was hearing, Rai Chattopadhyay was hearing this
Honorable
matter.
Justice Rai Chattopadhyay, my lord.
Sorry.
On the last, but previously, my lord, this bench has heard this matter.
Yes.
No, not today, not today.
Grateful.
Lordship, serial number 9, Lordship, I'm for the appellant, Lordship, for the state.
It has been dismissed.
Lordship will kindly recall the order because I was there. Lordship, I didn't understand it will be called. So,
You didn't understand.
Lordship, I apologize, Lordship. I was just.
Who is on the other side? 9?
Lordship, may it be.
Corona, dismiss Corona. Are you prepared to start?
I can, my lord, but perhaps, my lord, we won't
Oh,
finish today. It's not a regular bench. my
Not
lord.
today. Not today.
Grateful. Dismissed, my lord. For the respondent.
Dismissed. Usual order. Give your appearance.
Mentioned, my lord, on the earlier occasion, we said that the matter was going to get settled. We had offered, but there is no response also from their side. Just informing your lordships. Grateful.
দাঁড়াও দৌড়চ্ছেন একজন।
Grateful.
না ঠিক আছে।
But I'm being asked to seek for a not today because Mr. Shah is the counsel appearing
For
the appellant's petitions of
in 14.
this matter. Yes, Your Honor.
14. West Bengal State Electricity Board. Which Mr. Shah?
Mr. Jishnu Shah.
Not today.
My lord, then I shall take some time. Why, your lordship? Because we had offered a settlement. We have not received any.
Accommodation is no. The appellant is not represented. Stop. Paragraph. Learned advocate for the respondent number.
Your lordship, for respondent number 1, my lord, Ashok Jain.
Respondent number 1 says that requests that this matter may be listed a week hence. 1 week hence, or when?
2 weeks, your lordship.
2 weeks hence, so that the parties may explore the possibility of an out-of-court settlement. Paragraph, list the matter 2 weeks. 10 July, July 10.
Grateful, your lordship. The respondent.
I am appearing for you.
Respondent.
I am appearing for UCO Bank, Your Lordship. I was asked to appear in the matter. Disputes between two brothers. They had.
No, Mr. Dismiss. 15
He
dismiss.
records my presence because.
Give your appearance.
Grateful.
না 14 তো not today হয়ে গেল, not today না, 10 July. চোদ্দ নম্বরে the appellant is not represented. তারপরে কি আছে? 10
Respondent number one.
Learned advocate for the. Huh.
That the parties explore the possibility of out of court settlement is the matter of
Same order.
17, my lord, I am for the appellant, my lord. This is, my lord, an appeal against an execution order where we are the decree holder, where that eviction suit, my lord, the decree has been, the suit has been settled by the compromise. Compromise decree has been filed both of the parties, my lord. There are specific terms, my lord, that within 10 years, after 10 years, the judgment debtor will deliver up the possession.
This is the
Yes, my lord.
judgment of Justice Apurva Sinha Rai.
Yes, my lord.
পড়েছিল।
Whether the new, my lord, tenancy has been created or not.
Yes. So what you propose to do it? Your friend is not here. I don't know. Up to you.
I can start, my lord, on my lord. This is 5
Oh,
minutes.
একটা 10 বেজে গেল।
And it will take some time, my lord, because, my lord, the contention is that the new tenancy whether has been
আরে
created
চল,
or
আমরা
not.
উঠি। We'll come back at 2 o'clock. So what, you want to do it at 2 or we adjourn it for the day?
And adjournment maybe, my lord, because
The respondent is not represented. Stop. Learned advocate for the appellant, in her usual fairness, says that this matter may be adjourned for the day as she does not wish to proceed ex parte. Paragraph. List the matter once again. Monday করে দাও। এই ডাকো।
Lordship, kindly permit us item number 28. I am for the appellant.
20.
Item number 28, my lord.
28, yes.
Mr. Dotto is leading me in the matter. On the last occasion, we had completed our arguments, but my lord had directed the respondent to take a call on the per square feet rent, my lord.
Well, I have taken instruction with regard to the mean profit, my lord. My learned friend made a suggestion of 70 rupees.
We are not hearing the matter.
I am just seeking a not today because Mr.
Yes, very well. Not
My
today.
lord, item number 29, lordship of today's
Not
list,
today.
lordship.
Grateful, my lord.
My lord,
20.
item number 20.
Madam, why don't you let them finish? Please maintain.
I'm
Why
extremely-
are you so impatient? We are not running away. Yes.
Lordship, item number 16, I was just there. It's for just a single second call, my lordship. Lordship, kindly don't dismiss this matter.
Who are you for?
Lordship, I for the appellant in this matter.
And we'll hear you at 2 o'clock. We hear the appeal. And you, nobody else.
Lordship, it's a matter of 2006. It's a very old matter. My lordship.
2024 appeal.
No, my lordship, the original civil suit is of 2000 series. It's of different opinions and.
And therefore, you will not do it.
No, my lordship, Mr. Sakosin is leading in this.
Corona, dismiss Corona 16th, not today. Yes, now tell us.
My lord, item number 29 of today's daily list, lordship. I am led by Mr. Senior Counsel Jayanta Kumar Mitra. I am praying for 1 week time to come to get prepared,
29
lordship.
লেখো, on the request made 29.
29, lordship.
Request made on behalf of the appellant, let this matter stand adjourned and be listed again on সামনে বৃহস্পতিবার দিয়ে দাও।
Grateful, your lordship.
চলো। কিসের এডি? Oh, yes, Mr. Dashgupta.
But if your lordships take up this matter, may I mention, my lord, item number 15, my lord, that has been dismissed for default due to my non-appearance, my lord. Lordship will kindly condone that. If your lordship kindly, I'll mentioning
Original
upon
side,
notice.
original side 15টা করতে বারণ করো. Yes, yes, Mr. Dashgupta.
Grateful.
Mr. Bose, sorry. you know, when I was in the practice, I will not name the learned judge, a very fine person. In court number 5, I was appearing. So, with a smiling face, yes.
Of the respondents, my lord, in the morning I didn't have the instruction to appear in this matter. Yesterday, last night we have received the brief and I have instruction to appear in this matter, my lord, on behalf of the respondents.
Kotak.
Kotak Mahindra Bank.
Take instruction, come back on Monday.
There is a notice of conciliation.
My lord.
But I've checked it. It should not be conciliation because that's gone. 61 to 81 has been now
Yes.
now the mediation.
Mr. Bose, if you can come with an agreed order, talk to your learned friend. We'll keep it. This is appellate side.
Yes, my lord, this is appellate side.
So Tuesday it will be at the top.
My lord, may I indicate one thing, my lord? As per the Mediation Act, all the sections have not been notified yet. There has been a notification to the extent certain provisions of the Act has been.
Yes, we know that.
Yes.
But which provisions that I don't know.
My lord, I have the notification, my lord. Section 61, which is the amendment portion, which will amend the part 3 conciliation proceeding in the Arbitration Act, that has not been notified. So
conciliation is still there as a
yes,
concept.
Yes, my lord.
Fine. Mr. Bose has shown us a letter issued by your client's advocates.
I have came to learn.
Yes.
Yes, my lord.
Recording that conciliation should be resorted to.
Yes, my lord.
They are also agreeable. So, কি বলেছিলাম আমরা করবো?
Interim measureটা দিয়ে দিয়েছে। Interim measure has been passed.
করে দেবো, modify করে দেবো। যে inventory করুন, symbolic possession. We will modify the order of the appointment of receiver for taking physical possession. We will say inventory, yes. Symbolic possession, yes. Then try out conciliation. Otherwise, proceed before the arbitrator.
Kindly remember one thing with due respect, your lordship. Unilateral appointment. Unilateral appointment. That if your lordship sees the order of
your application is pending.
Pending, yes.
Yes.
Pending. That is
we will direct that application will be disposed of first before proceeding with the arbitration.
There's jurisdiction issues. There's a jurisdiction issues because
correct.
They have filed a section 6.
Correct. Issue. হ্যাঁ পড়ো না ওটা হবে না
টাইম ফ্রেমটা করে দাও আর একটু অ্যামাউন্টটা ঠিক থাকে
Yes, sir, we did. Money from the respondent. So that is
Onto the restructure and a proposal.
Yes, but you will have to cancel it.
Repayment of the loan.
Says that the arbitrator, even the purported arbitration clause may not be an arbitration clause.
He had agreed to the restructure.
In really never in the eye of law. In the eye of law.
He had applied for it. He had agreed. Thereby giving a go by to the arbitration process.
Is pending before the tribunal. In the meantime, an ex parte interim order has been passed. The operative portion whereof reads as follows. Page number 96.
Ex parte interim order has been passed by the arbitrator. Reads as follows. Paragraph. Learned advocate for the appellant also tells us that his client has received a letter dated June 16, 2025 from the advocates representing the respondent herein. Stop. By the said letter, the appellant has been called upon to participate in conciliation proceedings before the conciliator named in the letter. Stop. Paragraph. The respondent is also represented through learned counsel. Stop. Paragraph. We are of the view that the parties should try out conciliation. Stop. The appellant says that he will participate in such proceeding. Stop. Paragraph. We, however, feel that pending conciliation, the interim order passed by the arbitrator should be modified. Stop. Accordingly, we modify the interim order to the extent that the receiver appointed by the arbitrator you will should only make inventory of the articles mentioned in the order and take symbolic possession thereof without taking actual physical possession. Stop. The receiver shall also not interfere with the business activities of the appellant pending termination of the conciliation proceeding. Paragraph. In the event the conciliation proceedings succeed, nothing like it, stop. The disputes between the parties shall stand resolved in terms of the result of the conciliation, stop. In the event such proceedings fail, the arbitrator may proceed with the arbitration, but shall first decide the issue of his jurisdiction as raised by the appellant herein in his application under section 16 of the Arbitration and Conciliation Act. Paragraph. The appeal and the connected application stand disposed of accordingly.
Grateful, my lord.
No, I have also taken a point in section 16 that whether that clause actually amounts to an arbitration or not.
That pertains to his jurisdiction.
Yes.
Grateful, my lord.
There's only one thing. The date Date
was yesterday.
Date was yesterday. So
That you sort out now.
Nothing happened. They didn't turn up, my lord. Fresh conciliation proceeding will be initiated.
Well,
Actually, I'm for the respondent and Mr. Operative. I pray for not to. Thank you, Lordship.
See,
It's the day's accommodation.
I'm a last person to say no to a payment because some other day I'll be in the
there's-
same
yes,
difficulty.
correct.
I don't want to unnecessarily.
There's another practical difficulty. If this matter does not conclude today, the hearing, this is not the regular bench. From Monday, this bench is not available again. Anyway, since your learned friend, learned junior friend, with a smiling face, is requesting on the request made by learned advocate for the respondent, respondents, let this matter stand adjourned and be listed again on Monday or Wednesday.
My lord will kindly keep it on Wednesday if my lord so deems fit.
Wednesday, বুধবারের তারিখ দাও।
Monday. Second floor. ঠিক আছে একটা। My lord.
Respondent number 1.
Appellant. Appellant.
Yes, there are 3 appeals, madam. Appeal from a decree. There are 3 appeals, madam.
Yeah, there's some cost of 1 lakh or something. Cost.
That's yes. I think the Citibank's appeal is APD 2, which is with regard to the cost must be, madam. The first, which is item number 19.
Your client is Citibank.
No, she is appearing for Citibank.
I am the plaintiff, Jyotirmoy Palchori.
My client is
Lordship, I'm led by Mr. Arif Ali in this matter. I'm feeling, busy in some other court, Lordship. I'm paying.
Well, I will not stand in the way. After all, this is an appeal from a decree. My client is about 88 years old. Kindly fix it on any day, my lord, next week, because he would like to see the end of this litigation before the obvious happens.
Learned advocate for Citibank, NA Citibank, seeks adjournment. Paragraph. List this matter once again on Monday. Monday date thou within the first 3 items.
Grateful, man. point is very small. But of course, being a decree, certain things will have to be shown to your lordship.
Decree of this court?
I really suffered the decree. I'm the main person.
You are Shonali?
Yes. This is that matter, Lordship.
We always thought you were Aniruddha. All right.
It's like Mr. Chatterjee, Mr. Dashgupta, and then Dr. Chaudhary. I'm led by Mr. Senior Counsel Mr. Abhijit Mitra in this matter, my lord. There is some difficulty on his part. He was requesting if the matter.
Where is he? South Africa?
No, he's here in court, my lord. He's on his legs, my lord. He was requesting if this matter can be taken up on Tuesday, my lord.
On the request made on behalf of the appellant, comma, let this matter stand adjourned and be listed again on Mongolbarer Tarik diye do. Hey, দুখানা আছে, let these matters করো একসাথে।
23, my lord.
2020.
'24, my lord. I appear for the appellant, my lord. May I make a small request?
Yes.
Yes, my lord. May it be taken up after a fortnight?
For
Item
the
24.
appellant?
Yes, I am for the appellant.
All right. On the request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again on Tarik ta diye do.
Great.
Paragraph, since the respondent is not represented today, comma, the appellant's advocate on record shall communicate this order to the respondent's advocate on record. लिखले अभी लास्ट जेटा बोल रहा हूँ।
But I appear for the.
My lord, I appear for the appellant. I appear for the appellant, my lord. There was a direction for us to file paper books. We filed the paper books in the department. It's an appeal out of an order of dismissal of the suit, my lord, on the ground of only misdescription, according to the learned judge, of the defendant in the cause title. The learned judge has interpreted section 19 of the West Bengal Societies Act of 1961 to say that the defendant society has to be described with a personal name of the secretary in the cause title.
That's the act, my lord. That's not
No,
discrepancy in the
there
cause
is the
title.
judgment, division bench judgment of the
Formal
honorable
defect.
court, my lord.
Mr. Ali, curable defect anyway. Let us see. Are you both ready?
My lord, it's his appeal. He should.
My lord, if my lord, the paper books are ready, my lord.
Paper book.
I'm being led by Mr. Chaudhary, my lord, in this matter.
Led by?
Mr. Shobhoshachi Chaudhary in this matter, my lord.
Tell us frankly,
My lord,
you
my lord,
want
then
to...
we'll keep it next week, my lord.
Next week?
This is the short point involved. I just indicated, my lord.
Only not today.
We agreed
My
for
lord,
a Passover. He started pressing his matter.
No, there was no
Only not today.
oblige. Not today.
Oh, not today. Oh, again, we'll the press
My lord, I am for the appellant, my lord. I have taken out an application, my lord. My lord, you'll recall that the order was not complied. The occupational charges there was a delay in paying occupational charges for 3 months. For that, my lord, I have taken out an application for condonation of that. We have paid that occupational charge, my lord.
Who is for the respondent?
Your Lordship, I am for the respondent. Your Lordship, we would like to give an affidavit in opposition to the application.
Opposition?
Yes, Your
Haven't they paid?
Your Lordship, they have paid, but they have delayed, and we were allowed to take steps for execution of the decree if they delayed the occupational charges.
We will. File your opposition.
Grateful, Your Lordship.
এই GA2 বোধহয় দেখো তো
GA2, my lord.
একবার দাও পেলে কি প্রেয়ার আছে দেখি Time includes কালকে ছুটিটা ক্যান্সেল হয়ে গেছে
What, my lord, I have pleaded the reason for delay, my lord.
Execute for the position. This application has been taken out by the appellant, praying for the following orders. এটা ফেরত দিয়ে দাও। পেজ 8 এ দেখবে প্রেয়ার গুলো আছে, A B C খালি করে দেবে। Set out. Paragraph: learned advocate for the respondents seeks time for his clients to file affidavit in opposition. Stop. Let such opposition be filed within a week
Yes, your
from
lordship.
date. তারিখটা দিয়ে দিও ব্র্যাকেটে। Stop. Reply thereto, comma, if any, be filed within a week thereafter.
My lord.
তারিখটা দিয়ে দিও। Paragraph: list the matter 2 weeks hence. আবার তারিখটা হচ্ছে July 10, 2 weeks hence মানে।
Grateful, your lordship.
Praying for not today, my lord.
Appellant, on the prayer made on behalf of the appellant, comma, let this matter stand adjourned for the day.
And for the respondent.
My lord, on the last occasion, my lord was pleased to grant me leave to file affidavit in opposition to their demerit application.
But,
Demerit application, they are saying appeal is not maintainable.
my lord, because, my lord, they have already handed over peaceful vacant possession to us. And my lord, on that basis, we have already, my lord, withdrawn.
Very well.
the
Do you wish to
execution.
file in reply or not necessary?
My lord, my reply is ready, my lord. I shall file it in course of the day.
Oh, it has been already served on you. The
My lord, has been served.
affidavit in opposition filed on behalf of the appellant in connection with the respondent's demerit application, comma, be kept with the records. Paragraph: the respondent says that it will file its reply in course of the day. Stop. Let that be done with a copy to learned advocate for the appellant. Paragraph: list the matter once again Monday.
My lord, it's here, my lord, ready. I can file it now, my lord.
Oh,
Yeah.
have you given him?
My lord, I shall give him now, my lord.
তাহলে ওটা ওরভাবে লিখো না, বলো affidavit in opposition, যেটা বলেছি in connection whatever না, তার আগে we kept it আগে and affidavit in reply.
My lord, because I want.
আচ্ছা, এটা ছিল যেটা, ঠিক আছে,
I apologize, my lord.
যেটা ছিল, হ্যাঁ। আর লাস্টে কি বলেছি? On Monday নাকি
Tuesday.
Wednesday?
Wednesday.
Wednesday.
Great.
Obliged.
32.
Pass over.
33.
Pass over.
Lordship, I am praying for a not today.
Appellant,
I am praying
on
for
the prayer made on behalf of the appellant, comma, let the matter stand adjourned for the day.
But I appear for the respondent number 1 in this one.
35, pass over.
I am for the appellant.
Somebody was mentioning this matter,
He mentioned-
citing urgency. Yes. Yes, where's the respondent?
Shonok was they appeared on the last occasion when the matter was taken up.
Yes, but today he has disappeared, not appeared. So what to do? Tell us.
Only difficult, kindly fix any time on Monday, because my lord, this matter execute file an application challenging the maintainability of the execution on the ground that the decree has not become executable. The application was dismissed by the learned court. Now the execution is
This
fixed on
appeal is
Monday.
against that. Appeal is
It is
against
against
that.
that order dismissing my application.
No, so we will say they are not here. So let the execution not be proceeded with for the time being.
Kindly, my lord. stay.
Issue now. This matter was mentioned this morning on behalf of the appellant, citing urgency and praying for early hearing. Stop. The business of the court did not permit us to accede to such request. Paragraph, however, this matter has been called on in the usual course. Stop. Nobody appears for the respondent. Paragraph. It appears that the respondent has put what kind of decree?
Compromise decree and execution in a partition suit, my lord.
The respondent has put in execution a compromise decree passed in a partition suit. Stop. The appellant filed an application before the executing court, this High Court or some other court?
This court. This one.
Executing court. Executing court, challenging the maintainability of the execution application, contending inter alia, that the decree has not become executable as yet. Stop. Such application was dismissed. Stop. Hence this appeal. Paragraph. Mr. Ayun Banerjee, learned advocate representing the appellant, says that the urgency is that the execution application is scheduled,
1st July, madam. 1st July.
Is scheduled to be listed before the learned executing court on July 1, 2022, 25, sorry, 25, 25. And without an order of stay, the application may be proceeded with. Then shall we keep it on Monday once more? That's 30th June.
30th, if it is not taken up, Lord, then the next day. Kindly give me some protection. Kindly fix the matter.
Paragraph. Since the respondent is not represented today, we do not wish to proceed ex parte with this appeal. Stop. However, let there be, however, we request the learned executing court to defer the hearing of the execution application till the disposal of this appeal. For fortnight to take. No, not till disposal. For a fortnight, for the time being. Stop. Paragraph. List this matter once again Monday under the same heading before না মানে শোনো তোমায় বলে দিচ্ছি under the same heading এটা তুমি করো appeal from order এর উপরে দিয়ে দাও তাহলে কল হয়ে যাবে
Grateful.
First call also they were not here.
There, but Lordship, usually I would have prayed for a dismissal, but I have a cross appeal, Lordship. That may be listed along with these appeals, Lordship.
Our usual formula is that this will be dismissed. Your appeal will be listed.
Very well, Lordship. I shall indicate the number, Lordship.
Indicate the number.
Yes, Lordship.
Usual, dismiss for default. আর ওনার যেটা দেবেন ওটাকে লিস্ট করে দাও dismissed second call dismissed give your number you know if we don't follow our usual formula it will amount to discrimination.
I understand. I have suffered earlier today, and I was grateful to your lordships because.
Same.
It is your lordship. My lord, I appear on behalf of the appellant. My lord, this is an appeal from a decree in which, my lord, the learned trial judge has been pleased to allow the prayer of the respondent with regard to dismissal of my originating summons suit. Well, the case in short is both the parties are admitting the fact that the disputes involved in the originating summons suit is of such a nature that it cannot be summarily.
Mr. Ghosh, we'll we'll point out a practical problem. At 3 o'clock, we have fixed a matter.
Yes, my lord.
At 3:30, we have fixed a matter. This bench will not be available from Monday.
Yes. But
So
your lordship will then.
we'll only say not today.
As your lordship pleases. As your lordship. Obliged.
I'm for the appellant.
He is specially assigned.
Yes, before with this bench.
Yes.
This matter, your lordship will recall Mr. Jointo Mitra was arguing this flaring up of
Yes, 27%.
humble prayer, my lord. If one day can be fixed, my lord, he has more or less made substantial argument.
Mr. Shane, we'll again sit possibly on Thursday. Every week we'll sit once or twice, so long as these matters are there.
So, my lord, let this matter retain this same position.
Only not today. On the request made on behalf of the appellant, let this matter stand adjourned and be listed again when this bench is available, retaining its position.
Only prayer, my lord, renewal of my prayer of expeditious.
In fact, I had renewed the prayer on your behalf. I am enjoying it.
Knowing that you will make that prayer, he preempted you. This is the art of advocacy.
No, otherwise, if you said that I am enjoying an interim order, what is my problem? No, but till July we have the interim order. That is not a problem.
43. এটা আবার কি?
44 to 46, my lord.
না না এবার বলতে হবে, দেখো আমরা তো এবার স্পেশালি করছি। Yes.
But this
44 to 46, my lord.
that will also your lordship will recall, my lord. This is that
Reciprocal.
Yes, reciprocal obligations on the.
Does as it comes. But let them start, my lord.
And I'm being led by my lord Suryadev Mitra, my lord. He is not available today.
Not available.
Not available. No, it's not available. They have not even told him probably. Now it is
my lord.
told about the.
Please understand, from the next week, this bench will specially assemble only for these matters.
Yes.
And my lord, in fact, they submitted this fact and got the matter really, your lordship. Even in the other bench, your lordship had heard these matters.
So the next week, if you are
let it be made. If they ask for adjournment again, then your lordship will take it up in the regular bench.
Yes.
Every day it can be heard, my lord. We will
release from our list.
2013.
Yes.
Consent award of 2013, my lord.
But we have already started making submissions, my lord. Thereafter, it was released. It was not that we have not.
We will ascertain from Mr. Mitra next day whether he was informed about today's matter.
Problem is, they have group of counsel every day.
Accommodation is paid for on behalf of the appellants. Stop. Paragraph, list this matter once again when this bench assembles.
Deeply obliged.
But peremptory adjournment, one line, my lord.
It is not that the appellant has not moved,
to make
but the appellant was making its submissions. Thereafter, the bench was changed.
Under some sort of a
It
pressure.
is not right allegations, my lord.
Accordingly, let this matter stand adjourned peremptorily and be listed again when this bench assembles.
Obliged.
When this bench next assembles.
Deeply obliged.
47, my lord, is my appeal from decree. My lord would recall Mr. Rudraman Bhattacharya and Ranjan Bachawa, senior advocates, for arguing. My lord, the suit was, my lord, dismissed for want of, my lord, section 12A leave. So, my lord, it can be, my lord, on the last occasion we were here, but my lord was pleased to release because this particular bench has substantially heard the matter. My lord, it can be taken up next week, my lord, when my lord's assembles.
Not today.
Not today, my lord.
We are asking, not today.
Not today, my lord.
Why not today?
My lord, I'm led by Mr. Bachawat. My lord, he's in some difficulty today, my lord.
You are briefed in the matter.
My lord, I am. But my lord would recall Mr. Rudraman Bhattacharya has substantially placed the case. It was only few judgments that were.
What is the year of your enrollment?
2016.
16. So now you're almost a senior counsel.
If my lord so desires, I will start from next week, my lord.
Not today.
I'm so grateful.
I appear for the respondent, my lord.
Appellant nahi
My lord, may I just
Hmm?
make one prayer, my lord? The appellant on several occasions. There was one instance when my lord's pleasure was to dismiss the matter. They had it restored by mentioning. My lord, I'll indicate one difficulty which we are facing. If we are an MSME, my lord, the money has been stuck for several years now. This is a 37 in which we've succeeded before the single judge. Costs imposed upon them for lingering the matter for all this while. And they, before the 37 court, my lord, they keep on the same.
They are enjoying an interim order in the
My
appeal.
lord, they are, my lord.
Dekho, the appellant is not represented. Stop. Paragraph. The respondent, which is what is MSME?
My lord, micro, small and medium enterprise.
Micro, small and medium enterprise, bracket MSME, raises a grievance that the appellant is delaying the proceedings. Stop. The money due to the respondent under the concerned arbitral award
My lord.
is lying deposited in court,
My lord.
causing acute financial hardship to the respondent.
May I indicate, my lord, portion of the money, because that amount is also in dispute.
As a portion of the money. Stop. Paragraph. Let learned advocate on record for the respondent serve a notice on learned advocate on record for the appellant, intimating that if on the next occasion the appellant is not represented, the matter may be dismissed for default. The appeal may be dismissed for default.
Grateful, my lord. Grateful.
Item number 49, made please, my lord. My lord, your lord,
Yes.
recall, my lord, on the earlier occasion, my lord, this was delisted and it was directed to be come up together with the other matter of JSOP, my lord. My lord, may
ওই যেসব এর সঙ্গে করে দাও, যেসব গুলো তো আছে আজকে।
My lord,
Very well, it will be taken up. We will take
my lord, I was looking at the order passed in the JSOP matter, my lord. My lord, it has been directed to be listed on June 26th at 3:30 p.m. my lord.
Yes.
Lord, to kindly be listed together, my lord.
Yes.
My lord.
It will be taken up together today at 3:30. ঠিক আছে। ঠিক আছে।
For the appellant, I am being led by senior advocate Ranjan Bachawat. He is unwell. However, if on that ground,
What has
adjournment
happened
for
to
the
him? What has happened to him?
I was informed that he is unwell. The detail of which I am.
And you were not interested in finding out your senior is unwell. You won't find out if he needs any assistance.
Lordship, I will.
Acha, go find out. Not today.
Lordship, a small indulgence that item number 50 is a commercial matter. It is listed before this non-commercial.
Non-commercial. Commercially দিয়ে দাও। কেন হবে না? কমার্শিয়াল লিস্টে কেন হবে না কেন? Also regular bench. No, this will be under this heading only.
Lordship, if I may, is Is it possible for this matter to be fixed before this honorable bench at any day this bench is sitting?
Yes, we can fix it on 5th July.
5th July. Yeah. Much obliged, Lordship.
You'll come on 5th July.
I will, Lordship.
You'll come?
I will.
Sure?
Yes, Your Lordship.
Your senior will come.
I hope so, Lordship.
I'm not so sure. When you call him to find out how he is, you ask him whether he'll come to court on 5th July. No, we can't fix it, sir. We are just having some joke.
I understand that.
My lord, in item number 51, I appear for the Haldia Development Authority, my lords. My lords, if my lords recall, there were two appeals. One was filed by us, and the other one was filed by Konark. My lords, it has been inadvertently placed before the non-commercial list, my lords, and moreover, my lords, the other appeal that has been filed by Haldia.
Sir, there's no question of commercial, non-commercial. These are all specially assigned matters. There'll be only one list.
My lords, in that event also, my lords, there was another appeal which was
অন্য
filed.
অ্যাপিলটা বেরিয়ে গেছে, ওটা কেন বেরিয়ে গেছে দেখো। অ্যাসাইন হয়েছে কিনা সেটাও দেখে নাও। উইল ফাইন্ড আউট।
Very well.
কিছু আছে পাস ওভার? ও তো নেই।
I'm appearing for the respondent. Mr. Larry was submitting, Lordship.
In this way, Mr. Siddhartha Laird is appearing for the Union of India Railways. And he has left the court due to certain personal difficulty. I'm praying for not today, if it can be fixed.
Not today. এই আমরা 10 মিনিট ঘুরে আসি। ওরা এসে গেলে আমাদের খবর তো, যদি 5 মিনিট আগে এসে যায়, 5 মিনিট আগে খবরটা দিয়ে দিন। চলো আমরা চলে যাচ্ছি।
জ্যাসপটা 3টে ছিল না? 3টে না 3.5? আরে জ্যাসপটা কটায় আছে?
to conclude today.
But I'll be thrown out in case.
What
the
can be
order-
done? Your clients choose to stay away. Choose to stay away.
Decree that will be passed of eviction
Yes.
against me.
Yes.
If I'm not saying it
You're
will be.
assuming it will be.
No, I'm not
and
saying it
I
will
think
be.
maybe
But in the event it is, well, no, then I'll be thrown out of a property
be
without
thrown
even
out.
being heard. But gives me any day today after 3:30. I will not take more than 10 minutes. Not.
it was 5 minutes some time ago, so you know how much it will be now.
I can curtail that. But someday your lordship will hear me. Today, someday.
Give us, let us proceed. Today itself finish it. Yes, Ms. Shah, today itself. You are the Guptas.
Shroff.
Shroffs. No Guptas are involved here. I meant Shroffs, yes. So, you were brought in by Oriental.
Brought in by order.
Yes, all right.
Claimed under him.
They have not even filed their wakalat now. After yesterday's proceeding,
Yes,
now
you're on record. No, where's his wakalat? Find out, otherwise we can't hear you. Find out now, we'll hear you after yes. Ms. Shah will conclude in 10 minutes, she has promised.
My lord, I've made a short note, my lord, 4-pager. If I can just find out.
5 minutes, yes.
Property Act. What's the point?
My lord, the 4-pager, my lord. Short. I've included a short list of dates, my lord, because there was some confusion yesterday regarding whether the city court suit, my lord, the injunction order in the city, my suit, my lord, I was implemented therein after in this suit. My lord, there was some confusion. Mr. Ghosh had pointed out that no, it is the other way around. I'll just point out, my lord. My lord kindly sees in my list of dates, this suit, my lord, was filed in item number 7 in my list of dates, February 2016.
Yes.
My lord, I was not added as a party. After this, my lord, I filed item number 10, my lord, 9th October 2018, I filed the city court suit. Item number 11, 10th October 2018, that injunction order, the status quo order, my lord, was passed. After that, my lord, 19th November 2018, I was added as a party to this particular suit. After that order was passed. 18 December 2018, my lord, the plaintiff in this suit was re-verified. No whisper about my suit, where an order has already been passed, my lord, nothing. All that is suppressed by the plaintiff deliberately. They were aware of that suit, my lord. It was served upon them the very next day. After 2 months after that, they are re-verifying the plaintiff. All that is suppressed. Now, my lord, kindly. My lord, I have 2 documents to just show, my lord. My lord will kindly come to volume. Volume 2. My lord, volume 2, page 150, is my affidavit in opposition that was filed in response to this judgment upon admission application.
দাও কি দেখাচ্ছেন দাও
Volume 2, my lord, page 150. This is my affidavit in opposition to this application for judgment upon admission. My lord, I'll just point out 3 paragraphs from here. It kindly comes to page 155. Para B at page 155, my lord. I have stated that the last paid rent is 6361 per month. I am entitled to,
para
my lord, para B at page 155. This is 8B
8B, yes.
at page 155.
Yes.
My lord, I have stated that, my lord, 3 lines from the bottom, I've stated that I'm paying the last paid rent is 6361 per month, my lord. I say that I'm entitled to protection of the Rent Control Act. My lord, then at page 157, paragraph 8I, I have stated that I'm holding over in the premises. I'm there. I'm paying rent to the Shroff. They are continuing to accept rent from me. In page 159, my lord, para L, my lord, this I'll place. Para L at page 159, internal page 10, my lord. During continuation of the lease dated 29 September 1965, by a registered deed of lease dated 31st March 2001, the respondent number 7 to 9B demised the suit premises in favor of the petitioner herein, purportedly with effect from 1st October 2015. Such lease was executed, my lord, as said, without delivery or possession of the suit premises in favor of the petitioner, and the respondent number 1 continued to be in possession, my lord. Respondent number 1 is Orient. It continued to be in possession of the suit premises. As such, the lease dated 31st March 2001 is a nullity and should be declared null and void. My lord, these are some of the grounds that I have stated here, which in my very humble submission, my lord, whether if the lease today in their favor in trial is held to be null and void, my lord, then perhaps all these questions won't arise whether he has the locus to evict me from that premises. That would be under challenge. As a defendant, my lord, I perhaps cannot claim that anybody in my line, my lord, from whom I gain interest, I cannot challenge their right to evict me. But he is a third party. He has come and has been brought in later. So, my lord, I have raised this point. I am entitled to a trial on this point also, my lord. My lord, I have, in my note, my lord, I refer to 2 division bench judgments of this honorable court, which clearly says that if there is a lease without delivery or possession, my lord, that is invalid. My lord kindly sees. My lord kindly takes up my note once. If my lord kindly comes to my short points of arguments at page 4 of the notes, my lord, I'll quickly just place them. First, my lord, I have stated that the appellant cannot rely on other admissions apart from the one that is pleaded in his application for judgment upon admission. My lord remembers, in the application for judgment upon admission, there was only one ground. The Shroffs have given up possession, they have left, they have surrendered. Hence, since you are claiming under the Shroffs, you have to go. That is the only ground on which judgment upon admission has been claimed against me. They have, in the application, they have not placed one admission on my part. There are other, now they have tried to bring forth other things, whatever is cited in my deed and all that. But in the application, my lord, this is the only ground on which they have challenged it. My lord, for this purpose, I will rely on 2011-15 SCC 273. This judgment, my lord, in paragraph 7, Paragraph 7 of this judgment, my lord. If I may please. Once the claim of the respondent regarding admission was proved to be incorrect, his application for judgment on admission ought to have been rejected by the High Court. The High Court could not have embarked upon an inquiry as to whether there was some other admission or given a judgment on the basis of such other admission not pleaded by the respondent plaintiff. If the respondent wanted to rely on some other admission, it ought to have made a separate application so that the appellant could have filed his objections to the same. This was not done. In our case, my lord, it's only one ground, shofts have left. Now, my lord, I've stated that there's no admission on my part, and the admission, my lord, in terms of Order 12, Rule 6, has to be on the part of the party who is seeking to be bound by such admission, my lord. For that also, my lord, in this judgment only, I rely on paragraph 11. This is in point number 3 of my notes. Paragraph 11, my lord, kindly sees. It is true that a judgment can be given on an admission contained in the minutes of a meeting, but the admission should be categorical. It should be conscious and deliberate act of the party making it, showing an intention to be bound by it. Order 12, Rule 6 being an enabling provision, it is neither mandatory nor peremptory, but discretionary. The court, on examination of the facts and circumstances, has to exercise its judicial discretion, keeping in mind that a judgment on admission is a judgment without trial which permanently denies any remedy to the defendant by way of an appeal on merits. Therefore, unless the admission is clear, unambiguous, and unconditional, the discretion of the court should not be exercised to deny the valuable right of a defendant to contest the claim. In short, the discretion should be used only when there is a clear admission which can be acted upon by the party making it. So, my lord, there is, as I say again, the petition confines itself to a so-called admission on the part of the shroffs and no more than that. Now, my lord, I have for this purpose also relied on a judgment of 2000 volume 7 SCC 120. This is, my lord, I'll not bother my lord with the copies again. This is Uttam Sim Duggal only. I'll just place para 12, my lord. I think কালকে দেওয়া ছিল para 12, my lord. The last sentence that we were reading, my lord, that only, where the other party has made a plain admission entitling the former to succeed, it should apply, and also wherever there is a clear admission of facts in the face of which it is impossible for the party making such admission to succeed, my lord. It has to be on my part. My lord, I have listed out, my lord, the two judgments that I was trying to rely on, that there cannot be a lease without delivery or possession. The 2001 lease that is given in their favor, my lord, that itself, my lord, can be challenged, and I am in a position to challenge the same, being the defendant in the suit, if the suit goes for trial, my lord. My lord, firstly is the judgment of a division bench of this honorable court in 2006, volume 1 CHN, page 12.
We have noted the paragraphs. Next one, give us the next one.
The next one, my lord, is 2014, volume 2 CHN.
Judgment of the set aside. Set aside.
This is not Khaitan.
Question to set aside.
My lord, there is another judgment of Justice Devashish Kaur Gupta on the same line.
Which paragraph of this judgment?
My lord, I'll just point out this does not have paragraph numbers. My lord, kindly sees from an internal page number 3, my lord.
Yes.
The third paragraph onwards, my lord, it is submitted by Mr. Kausav Chandra Das, learned advocate, appearing on behalf of the appellants, that the learned trial judge failed to appreciate that the title suit was disposed of, holding that they had no title. According to him, the learned trial judge failed to appreciate the creation of a valid tenancy in favor of the appellants by the respondent number 3 in respect of the suit premises had been proved in the suit. According to him, the rent receipt.
It just
That-
follows the earlier judgment, nothing new.
This followed. These are two division bench judgments of this honorable court, my lord. Now, my lord, for Shroff, so far as the Shroffs are concerned, my lord, I would urge my lord to kindly take up volume 1 once. My lord, the affidavit of the Shroffs that was being relied on for the purpose of filing this judgment upon admission. Volume 1, page 114, my lord. The petitioners, my lord, have relied upon a portion of this affidavit which states that 2015 the lease has come to end, but the circumstances under which the Shroffs have surrendered, my lord, they have stated here. In my lords, kindly come to page number 131, my lord. They have said that this surrender was obtained by fraudulent misrepresentation by Awam, by the petitioner. They have, in fact, they have said that they are taking steps in this regard before an appropriate forum. My lord, kindly comes to page 131. This paragraphs, my lord, are few paragraphs are important. I'll have to place them. Page 131, para 22 onwards. The petitioner thereafter, on or about 31st May 2016, this was filed in this suit, my lord, in a different GA, informed the respondent numbers 2 to 5 that the terms of settlement has been prepared in accordance with the discussion held between the parties and requested them to arrange for execution of the same on that date itself. However, the respondent numbers 2 to 5 on that date itself wrote letters to its tenants, namely the parties ought to be added herein, requesting to hand over possession to the petitioner directly. The respondent numbers 2 to 5 immediately contacted the advocates and in fact availed upon the advocates to agree the draft terms prepared at the instance of the petitioner in view of the assurance and representation of the petitioner that the claim on account of mean profit would be foregone by the petitioner. The draft terms of settlement recorded that the respondent number 2 to 5 had surrendered the complete tenancy whatsoever under their occupation and they have handed over possession of the same in physical and symbolic to the petitioner. Next paragraph. The respondent numbers 2 to 5 subsequently came to realize that in view of the inducement of the respondent numbers 2 to 5 agreed to surrender possession in terms of the settlement on the basis that the claim towards mean profit would be foregone by the petitioner was actually meaningless since the petitioner has already realized the occupation charges. Since the petitioner had already entered into the separate agreement on 21st March 2016, which is prior to signing of the MOU with my tenants, and have realized from them huge charges in lieu thereof. The petitioner, after a few days, that is on 4th June 2016, informed the respondents that the terms of settlement have been prepared in accordance with the discussion held by and between the parties and requested them to arrange for execution of the same on that date itself. The respondent immediately contacted their advocates and in fact prevailed upon their advocates to agree to the draft terms prepared at the instance of the petitioner in view of the assurance and representations made by the petitioner that the claim on account of mean profit would be foregone by the petitioner. At the time of execution of the terms, the petitioner, with regard to paragraph 9 of the terms, called upon the respondent numbers 2 to 5 to sign a draft letter prepared by the petitioners to be issued to the tenants of the answering respondents, which was signed by the respondent numbers 2 to 5. The respondent numbers 2 to 5 came to realize that the inducement to the respondent numbers 2 to 5 to agree to surrender the possession and enter into the terms of settlement on the basis that claim towards the mean profit would be foregone by the petitioner was also actually meaningless, since the petitioner had already realized huge charges from some of the tenants of the respondent numbers 2 to 5. Even apart from the aforesaid aspect of inducement offered by the petitioner, causing the respondent numbers 2 to 5 to settle with the respondent numbers 2 to 5, the settlement is also otherwise unenforceable in view of the fact that the liability of the parties with regard to arrears of corporation tax has not been crystallized and made certain by the said terms. In fact, the said settlement clearly stipulates that the petitioners undertake to wait till the final outcome of the writ petition presently pending for adjudication before the Honorable High Court at Calcutta, including any appeal or appeals from there before any competent court for a reasonable period. Thus, by reason of the said stipulation, the agreement sought to be entered into by the parties has been meant contingent upon the outcome of the writ petition, implying thereby that the settlement is not enforceable at present. Furthermore, the clause to a certain extent is also vague and ambiguous, inasmuch as the waiting period contemplated thereunder is not precisely defined and is clouded with uncertainty by use of the expression for a reasonable period. Furthermore, the terms of the said agreement stating that the claims of mean profit would be foregone by the petitioner against the answering respondents have not been honored by the respondent. I state that the said agreement was meant to be filed before this honorable court for decreeing the instant suit in terms of the said agreement have also not been honored by the petitioner. I state
This affidavit
My lord.
was filed in response to what? Amendment application.
An amendment and impleadment application, my lord, whereby a number of other, my lord, including me, others were impleaded,
Right.
including the Shroffs, my lord. Continuing, my lord, though this instant petition for amendment is seeking to indirectly procure a seal of this honorable court to the otherwise defunct and unlawful terms of settlement dated 4th June 2016. The agreement is thus otherwise not lawful and cannot be approved by this honorable court.
Yes.
My lord. It was only upon the execution of the instant terms of settlement that the answering respondents came to learn that no settlement was entered into with the respondent number 1 and that the petitioner had made deliberate misrepresentation to the aforesaid effect, which was one of the factors that induced the respondent numbers 2 to 5 to settle in haste with the petitioner. My lord kindly gives a note of My lord, para 27, my lord, kindly marks this is a specific case of deliberate misrepresentation to have this settlement worked out. Next para, my lord. The terms of settlement which were entered into by and between the petitioner and the respondent numbers 2 to 5 were based on deliberate misrepresentations of fact made by the petitioner, and the said terms of settlement thus stand vitiated on account thereof and cannot be acted upon any further. The petitioner had, in violation of the order of injunction passed by the learned city civil court in title suit number 1405 of 2015, which is Shroff's suit, my lord, secretly and behind the back of the respondent number 2 to 5, had entered into a secret arrangement with the tenants of the answering respondents.
Terms of settlement were challenged before any competent forum.
My lord, I was searching, my lord, the records of the city civil court. We found that there is a suit which has been filed in 2024 by the Shroffs against the petitioner, my lord. We do not know what we have to, my lord.
Mr. Banerjee will tell us later. You've ascertained about the wakalat. Yes, that's enough. Ms. Shah, we have heard enough.
This,
Yes.
whether if this, my lord, are tested on trial, my lord, I see that irrespective of whatever has been stated and whatever is deemed to have been admitted, my lord, by the Shroffs on my behalf, they could not have first thing. Secondly, today I have a right to question their authority to evict me. I have said that their lease could not have been granted in their favor because it is not coupled with delivery of possession. I have a right to challenge the lease. And number two, this particular settlement which the Shroffs have at least challenged here in this particular affidavit. I do not know what is there in the WS, my lord. That also should
Sure. Yeah.
That also should.
Ms. Shah, learned counsel representing the respondent number 13 concludes her argument. Paragraph lists this matter once again. When this bench next assembles, at the top of the list. Stop. On that date, we will very briefly hear learned counsel for the respondent number 14, as also learned counsel for the defendant numbers 2 to 5.
Lord, 2 to 5 did not, my lord, file written statement, did not contest the proceeding before the first court, was not there here. My lord, they are watching yesterday's event and has been set up yesterday.
Set up, I don't know.
So, my lord,
Certain things we understand, Mr. Chaudhary.
and that is why there is no wakalatnama also.
Subject to the wakalatnama being filed by learned advocate on behalf of the said defendants. In view of the fact that we are almost towards the end of the hearing of this matter, let this matter be treated as heard in part by this bench.
My lord, kindly records that I have submitted my written notes.
Ms. Shah concludes argument, written notes of argument.
And my lord,
submitted on behalf of respondent number 13, we get with the record.
My lord, in the written notes, if I may just point out, because I won't get any chance any further, paragraph 9 of my written notes, my lord, I have indicated what are the sum travel.
Why do you think we are not going to read your note?
My lord, but I will not get a chance to place it. That I'm sure. That's why.
One thing I'll fail in my duty if I don't point this out, because I wanted to point this out, but I was virtually yesterday, could not have. But I don't know, Mr. Chaudhary has also not indicated. There's no question of setup because I'm here. But I wanted to address your lordship, finish it, conclude it today. But I don't know, subject to.
No, set up not Mr. That Banerjee. Mr. Shudra Banerjee.
I do not know, because subject to correction, that this will be a commercial dispute because the building is used for a commercial purpose. So to
argue that.
No, of course, but to come and see.
Next matter.
I'll order to set aside for it.
বুধবার বা বৃহস্পতিবার
Made, please, Lordship. Well, on the last occasion, I was placing before your Lordship section 434 of the Companies Act, and particularly the provisos. I will request your Lordship, my lord, to take the Companies Act first. I have shown to your lordship, my lord, the main provision of section 434, 1C, and then, my lord, I was placing the provisos. And my submission is this, that the wide language in the main provision has been explained, I should say, to a large extent by the provisos. Because, well, if one doesn't look into the provisos, as I submitted to your lordship, it seems that all proceedings perforce will have to be transferred to the tribunal, and the tribunal was given liberty to proceed to deal with the proceedings from the stage before their transfer. That is, my lord, the main proviso 434(1)(c). And I have shown to your lordship that in pursuance of the first proviso, the central government has laid down, my lord, certain rules, which copy of which, my lord, I have handed over to your lordship. There are 2 sets of rules have been at different points of time, by which, my lord, it seems that the wide terms of the main provision has been, because, well, the proviso says only such proceedings relating to winding up of the company shall be transferred to the tribunal. It appears, my lord, this is how I look at it, that all proceedings in respect of arbitration, compromise, arrangement, reconstruction, and winding up, they are liable to be transferred. But, my lord, some exception has been made with by way of this, through these provisos, with regard to winding up proceedings. And, my lord, the winding up proceeding, in respect to the winding up proceeding, the first proviso says that only such proceedings will be transferred to the tribunal that are at a stage as may be prescribed by the central government. And central government has prescribed the stage before, my lord, the admission of the application. Then, my lord, so far as second proviso is concerned, it doesn't apply to us. This is with regard to other cases other than winding up. Third proviso is provided also that my lord, I am not going to trouble your lordship, all proceedings under the Companies Act 1956, other than the cases relating to winding up. So this is also not one of those your lordship need not consider. The second proviso, my lord, II of the third proviso, that the proceedings relating to winding up of the companies which have not been transferred from the High Court shall be dealt with in accordance with the provisions of the Companies Act 1956. So, my lord, I read this provision, my lord, as a, so to say, as an appendage to the main provision. Those which have not been transferred in terms of, my lord, the main provision along with the first proviso will be continued to be considered by the High Court. Then, my lord, comes the fourth proviso. But this also doesn't apply to us. This is related to cases of voluntary winding up. Your lordship is pleased to see, provided also that proceedings related to cases of voluntary winding up the company by notice of resolution of the advertisement, etc., it doesn't apply to us. Then, my lord, we come to the fifth proviso, which is a very important proviso, my lord, which has come by way of amendment only in 2018. The other provisos at different points of time. After 2013 Act, my lord, the provisos have been added 2016, 2017. This one is 2018. Provided further that any party or parties to the proceedings relating to the winding up of companies pending before any court immediately before the commencement of the Insolvency and Bankruptcy Court Amendment Ordinance 2018 may file an application for transfer of such proceedings, and the court may by order transfer such proceedings to the tribunal, and the proceedings so transferred shall be dealt with by the tribunal as an application for initiation of corporate insolvency resolution process under the Insolvency and Bankruptcy Code. So, my lord, so the fifth proviso is concerned, this to a large extent, I should say, has watered down the mandatory language of the main provision. In the main provision, it shall stand transferred to the tribunal. And here, my lord, clearly a discretion has been given. First of all, if there is no application is made by party or parties to the proceeding, then the court will not consider that question of issue of transfer, because whether the party may, and then whether the second may is the court may by order.
What happened before this fifth proviso was introduced? The proceedings did not get transferred. Language is shall stand transferred.
But my lord,
clear enough.
My lord, as your lordship sees, may deal kindly see pending immediately before the shall transferred, may that is, my lord, coupled with the proviso. The first proviso, my lord, was from the very beginning.
No, that there are some restrictions, stage, etc. You forget.
And Lord,
But
what it says is,
I am on requirement of an application. Without application, it will not stand transferred.
My respectful submission, no. Kindly note two things. First is an application, and who is to make the application? Not my lord myself,
yes,
or my learned friend, outsiders. Has to be, my lord, a party or party to the proceedings relating to winding up. So, my lord, if a party or party goes out of the proceedings, winding up proceeding, he is not entitled to make the application.
Before introduction of fifth provision, then
yes,
proviso, nobody could make an application. There was no provision for
there
application.
is no provision for.
What was the effect? There was no transfer.
No. At that point of time, my lord, if there was no proviso, then my lord, there is no question of, my lord, anybody making any transfer. The proviso says, proviso says further that any party or parties to any proceeding relating to winding up of companies pending before the court immediately before the commencement of so and so may file an application, and the court may by order transfer. So I am asking this question myself. Your lordship is perfectly right in asking me this question. Supposing this proviso was not there, and the other provisos were there, then my lord, first the main provision 434(1)(c), that it shall stand transferred. But the proviso, my lord, which follows immediately and which was there from the very beginning, that proviso says such proceedings will be transferred as are at a stage as may be prescribed the Senate.
That is a different aspect. That is a different aspect.
So, my lord, the shall stand transferred, only such proceedings as the central government by notification will be.
Correct. But you say after the fifth proviso came in, it shall not stand transferred. One has to apply, one who is entitled to under this proviso,
yes,
and on that application, the court may or may not
my lord, yes,
direct
my
transfer.
submission is this, that the legislature was quite conscious as to who has the locus standi to move the application. A person who does not, my lord, is not a party to the proceedings of winding up, has no right to move the application.
Learned judge has held that they are parties because it's an in rem proceeding.
My lord, in that I shall come to that immediately. That my submission is this, that by reason of the orders of the court, it has been specifically said that they are no longer parties. They wanted to stay out of it.
Those orders we have seen, the division bench.
Yes.
Justice Banerjee, Justice Mukherjee.
Yes, Mukherjee, your lordship is pleased to see that. So I shall come to that immediately. But before I do that, my lord, I think I should also draw your lordship's attention, my lord. This submission of mine will be incomplete unless I, my lord, show your lordship the transfer rules. The rules have been framed under this. And that your lordship will be pleased to find, my lord, companies transfer of pending proceedings rule 2016. I don't know whether your lordship's copy has got that rule. But I think separately.
Copies have been given, there's a gazette notification, 2 gazette notifications, my lord, of 16 and 17.
2016 and 2017. Yes. We দেখো দুটো আছে.
Initially of 16 and then amended in 17.
Those we have seen.
Oh. 2016.
Yes.
Transfer. Kindly first see 2016 notification. Rule 5.
This is too wide. Where the petition has not been served, that is the stage.
All petitions relating to winding of a company under clause E of subsection 433 of the Act on the ground of inability to pay its debts pending before the High Court, and where the petition has not been served on the respondent under Rule 26 of the Company Court Rules, shall be transferred to the bench of the tribunal established under subsection 1. This was the 2016. And 2017, 2017, your lordship has got 2017. Well, now that particular rule has been substituted by Rule 7, the rule which has been enacted in 2017. And here also, where the petition has not been served. Oh, there are other provisos there. Well, here the main rule remains the same, where the petition has not been served. But my lord, there are two provisos added there. First proviso is, provided the petitioner shall submit all information other than information forming part of the records transferred in accordance with Rule 7 required for admission of the petition under Section 7, 8, and 9 of the Code, as the case may be, including details of the proposed insolvency professional to the tribunal up to the 15 July 2017, failing which the petition shall stand abated. The next proviso is, provided further that any party or parties to the petition shall, after the 15th of July 2017, be eligible to file fresh application under Section 7, 8, or 9 of the Code, as the case may be, in accordance with the provisions of the Code. Then, third proviso is, provided also that where a petition relating to winding up of a company is not transferred to the tribunal under this rule and remains in the High Court, and where there is another petition under clause E of Section 433 of the Act for winding up against the same company pending on 15 December 2016, such other petition shall not be transferred to the tribunal, even if the petition has not been served on the respondent. So, my lord, ifs and buts throughout with regard to transfer. But what I want to emphasize is this, that it seems that this imperativeness of the transfer, that, my lord, has been to a large extent watered down by these rules. And these are central government rules. These are provisions which are there in terms of, my lord, the first proviso.
The orders passed by this court, 446 after this. And ever break for this.
Well, lord, here I have shown to your lordship that the courts have passed order, Mrs. Mukherjee and Mrs. Banerjee in the division bench, recording that they have gone out, so to say, my lord, from the winding up proceedings. Lordship has been pleased to see, my lord, the order of Mrs. Mukherjee is, hence it has been taken that the secured creditor Edelweiss Asset Company Limited has no objection to the setting aside of the winding up order. And, my lord, the first sentence, today, Mr. Adia, for the... Yes. Page 140, but I have placed it before my lord has got them. For the secured credit submit that a client wants to stay outside the winding up proceeding and pursue their claim otherwise in accordance with law. But the language is very clear. I want to stay out of it and I want to pursue my claim otherwise. And they have, my lord, proceeded before the DRT. And, my lord, your lordship has please to pull them.
No objection to the setting aside of the winding up.
That's right. And your lordship is pleased to see the second sentence also, that no objection to the setting aside of the winding up order. So, my lord, they were quite content to keep the company alive, because they would be proceeding as the company in a different forum for the purpose of recovery of their dues. Well, in this connection, I mean, since I am on this, And this, your lordship is pleased to see, the order of Mr. S. Banerjee also, the same thing has been recorded. Okay, to the yes, page 178 at 179, third paragraph, last sentence. The impugned order was passed on a petition under section 466 by the contributories. The petition is yet to be disposed of, etc. And then the last sentence of that. Two other secured cases of company liquidation are Edelweiss and ASREC. Both Edelweiss and ASREC are represented. Both sets of secured creditors seek to stand outside the liquidation and are pursuing claims with the appropriate debt recovery tribunal. Well, I submit to your lordship, my lord, it is quite clear from these orders as recorded that my learned friend's client wanted to stay out of the winding up, didn't object to the winding up order not being passed, and my lord, they wanted to pursue their own proceedings before the proper forum. So, my lord, my respectful submission is he is, my lord, a party or to any proceeding relating to winding. He is not a party to any proceedings anymore. That will be my respectful submission. On this aspect of the matter, my lord, I would request your lordship to look into one judgment. I shall come back to this judgment again. Okay, Navin Chandra's judgment is also. Actually, paragraph. Yes, my lord, this is, I will cite this judgment again, my lord, in connection with the my main matter in controversy. But on this aspect of the matter, that my learned friend's client is outside the winding up, on this, my lord, one paragraph I would like to place before lordship. This is, my lord, 2021 4th Supreme Court cases 435. Navin Chandra Steel Private Limited versus Shrey Equipment. Lordship will be pleased to come to paragraph 27 at page 455. Well, at this paragraph, it is settled law that is secured creditor stands outside the winding up and can realize its security divorce winding up proceedings. In M.K. Ranganathan versus State of Madras, this court held, then quote, para 15, the position of a secured creditor in the winding up of a company has been thus stated by Lord Grenberry in Food Controller versus Cork. Then quote, the phrase, within inverted commas, outside the winding up is an intelligible phrase if used as it often is with reference to a secured creditor, say a mortgagee. The mortgagee of a company in liquidation is in a position to say the mortgage property is to the extent of the mortgage my property. It is immaterial to me whether my mortgage is in winding up or not. I remain outside the winding up and shall enforce my rights as mortgagee. This is to be contrasted with the case in which such a creditor prefers to assert his right not as a mortgagee, but as a creditor. He may say, quote, I will prove in respect of my debt. If so, he comes into the winding up. Clear. Then it says, it also summarized Palmer's Company Precedents, Volume 2, page 415. Then quote, sometimes the mortgagee sells with or without the concurrence of the liquidator in exercise of a power of sale vested in him by the mortgage. It is not necessary to obtain liberty to exercise the power of sale, although orders giving such liberty have sometimes been made. The secured creditor is thus outside the winding up and can realize its security without the leave of the winding up court. So, my lord, this is the first point I took before your lordship, that is my learned friend's client entitled to move the application for transfer? My lord, I lost that in the trial court. the court was pleased to, my lord, receive the application and pass an order for transfer. I submit to your lordship that perhaps I can, my lord, with some amount of assurance, my lord, I can assert before your lordship that a person who has chosen to remain outside winding up, he is not a person who is my lord, the language is a party or party to the proceedings. And this is clear, my lord, exposition of the law. Secured creditor is thus outside the winding up and can realize security without the leave of the winding up.
Mr. Mitru, just for my education, if I'm a secured creditor,
lordship,
if the value of the security is found to be less than my claim, can I not firstly enforce my claim against the security?
Lordship.
And to the extent my claim remains unrealized, participate in winding up, is that possible or not?
Yes, your lordship kindly comes to this is exactly what, my lord, this judgment says, well, Food Controller versus Cork, the appeal court decision, page 55, Placitum C, paragraph 27. Kindly see what it says. It says that it is immaterial to me, and he is saying, this is the secured mortgage, secured creditor is saying, it is immaterial to me whether my mortgage is in winding up or not. I remain outside the winding up. He has to say, I remain outside winding up and shall enforce my rights as mortgagee. This is exactly what he did. And that has been recorded by Mrs. Mukherjee. That's been recorded by the division bench. And then he says, this is to be contrasted. Kindly see the next sentence. This is to be contrasted with a case in which such a creditor prefers to assert his right not as a mortgagee, but as a creditor.
That's not my query. These are two different ways of enforcing my recovery.
Absolutely.
What I am on is, if the value of the security
is less
than my claim,
yes,
can I not first exhaust my remedy against the security,
yes,
and to the extent my claim remains unrealized, participate in the winding up?
Then you come and participate in the winding up. Then you don't stay outside winding up. Don't declare that I stay outside the winding up. Don't say that I want to remain outside the winding up. Do not proceed by way of realization of the dues before the DRT. Well, a person cannot, my lord, have, if I may use that expression, have it cake and eat it too. I don't know what it means really. I often wonder, unless you have the cake,
how can you eat it?
How can you eat it? Quite right. But my lord, this is most of the time this is being said in this connection. My lord, I am submitting to your lordship that you have got a choice in the matter. If you stay outside the winding up, you stay outside the winding up. And my lord, I should show you what they did was, they stayed outside the winding up, proceeded before the DRT. And now, my lord, my learned friend's client has now moved this Section 7 application under the IBC. And my lord, trying to pursue the remedy by way of, my lord, this resolution process. But I am submitting to, I shall show to your lordship, perhaps that is not permissible. I shall come to it afterward. But what I am on is this particular, I mean, the pronouncement is quite clear as to who stands outside the winding up. And if a person stands outside the winding up, then, my lord, he is not a party or party to the proceedings. This is my short point. This is one aspect of the matter. And the second aspect of the matter is the imperativeness of, my lord, transfer. The court said that irreversible, and it is not irreversible, and therefore it should be transferred. Well, I will submit to your lordship that none of the Supreme Court has gone that far. The Supreme Court has not encroached onto the discretion of the court, which has been conferred by this section and the provisos. That is my reading, my lord, my humble reading of the decisions. The two decisions, my lord, which had been referred to in the judgment, impugned judgment, my lord, I will just draw your lordship's attention. And, my lord, your lordship will please to consider whether the learned trial judge was right in, my lord, proceeding on the basis with regard to the mandatory nature of the transfer, the provision. My lord, kindly take, my lord, there are two decisions. One I shall cite, my lord, is Action Ishpat, that is 2021, two Supreme Court cases, page 641. Well, before I do that, in fact, no, very well, my lord. Let me place it, and then I shall go. My lord, I will address your lordship to some extent. The operation of the proviso, to what extent it affects the main provision, the substantive provision of the act. And my lord, there are some decisions which perhaps will throw some light on the subject. Because, my lord, I could see that the provisos which I have placed before your lordship had caused some amount of, generation of thought process in your lordship's mind as to what is the effect of the mandatory direction contained in the substantive provision in view of the provisos which followed. So, my lord, there are some decisions, I shall come to that. But before that, my lord, kindly take, my lord, Action Ishpat at page 10 of this compilation. Lordship will be pleased to come to a few paragraphs. I would request your lordship, my lord. Section 434 had been set out here, but at that time, yes, all the provisos were there. Section 434, along with the provisos, have been set out in paragraph 6. Then kindly come to paragraph 7. Or I should say, my lord, this is a quotation from yes. Well, this is a quotation from the impugned order. Kindly come to paragraph 7 of the at page 648, Placitum A. This court has already, in Rajni Anand versus Cosmic Structure. Sorry, Lordship has got that. Paragraph. This is at page 648, Placitum A. The quoting from the trial court, the impugned judgment which has been appealed from.
Yes, Rajni Anand.
Yes, this court has already, this is a quotation from the appeal court judgment. This court has already, in Rajni Anand versus Cosmic Structure Limited, well, that is, it seems it's a Delhi judgment, held that the power under section 434(1)(c) of the Companies Act 2013 for transfer of a petition to NCLT is discretionary and has to be exercised in the facts and circumstances of the case, so as to expeditiously deal with the proceedings winding up. Then 8. In my opinion, it would be in the interest of justice and in the interest of respondent company that the creditor and the creditors that the matter be transferred to NCLT in exercise of the discretionary power of the court under section 434 of the Companies Act. The order appointing OL is a recent order, and not much time has elapsed since then. This is the distinguishing feature. The official liquidator has only taken steps to seize the office of the respondent company and the factory premises, and further exercise is yet to be carried out. The application is allowed as above. Now, my lord, then kindly come to the Delhi judgment. I will not trouble your lordship with this. Kindly come to then the argument made at page 650, the running page 19, the judgment page 650, running page 19, paragraph 3. A.K. Venugopal, learned Attorney General for India, appearing on behalf of SBI, countered all these submissions. According to him, this court has unequivocally laid down that the fifth proviso to section 434(1)(c) of the Companies Act 2013 now makes it clear that a discretion is vested in the Company Code to transfer winding up proceedings to NCLT without reference to the stage of the winding up. Even post-admission, according to the learned General, if no irreversible steps have been taken, then a combined reading of fifth proviso to section 434(1)(c) and section 238 of the Code would lead to the result that the winding up proceedings be transferred to NCLT, as not only is the Code a special enactment with the non-obstante clause, which would, in the case of conflict, do away with the Companies Act 2013, but also that, given the judgment of this court in Swiss Ribbons, winding up is a last resort after all efforts to revive the company has failed. Therefore, my lord, the endeavor is to revive the company, not to put it to sleep. That is, and this is what was argued. Then, my lord, kindly come to. I will request your lordship, my lord, I am not placing independently Swiss Ribbons case, which has been quoted in extenso here. Kindly, my lord, come to page 652. But running page 21 of this judgment. The court then went on to state in Swiss Ribbons case, that's been quoted, para 27, as is discernible, the preamble gives an insight into what is sought to be achieved by the code. The code is the first and the foremost a code for reorganization and insolvency resolution of corporate debtors. Unless such reorganization is effected in a time-bound manner, the value of the assets of such persons will deplete. Therefore, maximization of value of the assets of the person. Sorry. Well, I'm sorry.
We don't have the page numbers of the compilation.
Oh, I see. Of course, I will give you. Well, I don't. I thought that it has been given to you earlier. Don't junior design. It is সুবিধা হবে yes. Page 21 দেখাচ্ছি দেখো তো ঠিক I generally don't cite decisions without giving a copy.
No, decision, it's reported. I don't have a problem.
No,
if
but
the report page is given, but my lord, compilation page, my lord, creates a problem.
No, quite apart from that, my lord, I generally follow this practice. I think, my lord, this is the Supreme Court practice. You give the other side the copy that you are citing. I'm sorry, I didn't know that.
No, my lord, this is fine. So it's para 27 of Swiss Ribbons, my lord.
Yes.
Paragraphs, my lord.
Yes, I
lead up to 27 in the report. That's what.
No, I said so. In Swiss Ribbons case, para 27. But if I may just place it. As is discernible, the preamble gives an insight into what is sought to be achieved by this code. The code is first and foremost a code for reorganization and insolvency resolution of corporate debtors. Unless assets of such persons, unless such reorganization is effected in a time-bound manner, the value of the assets of such persons will deplete. Therefore, the maximization of value of the assets of such persons so that they are efficiently run as going concern is another very important objective of the code. This in turn will promote entrepreneurship as the person in management of the corporate debtor are removed and replaced by the entrepreneurs. When therefore a resolution plan takes off and the corporate debtor is brought back into the economic mainstream, it is able to repay its debt, which in turn enhances the viability of credit in the hands of banks and financial institutions. Above all, ultimately, the interests of all stakeholders are looked after as the corporate debtor itself becomes beneficiary to the resolution scheme. Workers are paid, the creditors in the long run will be repaid in full, and the shareholders, investors are able to maximize their investment. Timely resolution of a corporate debtor who is in the red by an effective legal framework would go a long way to support the development of the credit market. Therefore, my lord, what it says is this, that the basic feature of these provisions is to somehow revive the company, not to, my lord, to send it to winding up. Therefore, one has to take steps for doing that. course, my lord, if I may just digress for a moment from this, I do not know this. I mean, I should say very high hopes that the Supreme Court has shown. To what extent, my lord, in actual practice, it has been effective? Because I find, my lord, I have come across cases where, my lord, the company had gone into corporate resolution process, and my lord, before the committee of creditors, when my lord and before the resolution professional, when my lord the debts are narrated and they are recorded, particularly I find the financial creditors get their dues, but operational creditors, my lord, in many of the cases I find they are just given a pittance of the claim, of the actual claim. Particularly, my lord, in construction companies, my learned friend will bear me out and also correct me if I am wrong. I find, my lord, particularly in a construction company, if it goes into liquidation, the contractors and subcontractors who had worked for the company, they are hardly, my lord, given anything, because the entire money on liquidation goes to the, my lord, the operation, the financial creditors. And the COC, the Committee of Creditors, consists mostly of, my lord, the banks and financial institutions. So, well, as my learned junior says, that this is from experience we are coming, well, lord, that electricity dues completely wiped off. Nothing is being paid. No money is left for the purpose of payment. Therefore, reviving a company, but putting other companies into liquidation. Ultimately, it so happens. Anyway, this is what, my lord, is what had impressed the court. Timely resolution of a corporate debtor who is in the red by an effective legal framework would go a long way to support the development of credit markets. Since more investment can be made with funds that have come back into the economy, the business then eases up, which leads overall to higher economic growth and development of the Indian economy. Then, my lord, kindly come to para 28. It can thus be seen that the primary focus on the legislation is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from a corporate death by liquidation. The code is thus a beneficial legislation which puts the corporate debtor back on its feet. Now, I ask this question to myself, my lord, when a scheme application is made, then, my lord, the purpose of the scheme application is to revive the company. Section 466 application basically is that a person comes forward and says that I will pay the debts which have, my lord, have been put forward for the purpose of liquidation of the company. He goes on making payment of this. The winding up is wiped off. The workers' dues, which have been lying outstanding over a long period, which the company was unable to pay, by way of a scheme action, if it, my lord, is such that by reason of the scheme, the workers are also paid, then, my lord, this is for the revival of the company. And this is precisely the purpose which, my lord, this judgment has, my lord, referred to in these paragraphs, that the revival of the company is the primary purpose. Then, my lord, if revival is the primary purpose of, my lord, IBC, then, my lord, if I revive under the old Companies Act and in the winding up proceedings, which is permissible under section 466, should the court say that an irreversible situation has arisen, should the court not exercise its discretion in favor of the person who is making the application? This I am asking this, my lord, this question to myself for the purpose of finding out as to if this is the main purpose, and that is the purpose I am seeking to serve, then why should I not be given a trial, given an opportunity to do so? And once it goes before the, my lord, under section 7, 8, 9, 14, 10, 14, my lord, once it goes that way, then I just ask this question to myself, what will happen to the persons who I have paid already? I have shown your lordship page 172, na? That so much of payments have been made. I won't get back my money.
I'm not a creditor.
I won't be standing in the position of a creditor. What happens to the amounts which I have paid to the workers? Pursuant to court order. And these are all pursuant to court orders. So, well, this is, I am telling you, Lordship, why this? For the purpose of, my Lord, finding out as to in which way your Lordship's discretion will be exercised. The issue of discretion, exercise of discretion. And, my Lord, this court has said repeatedly, well, in this judgment and another judgment, that it is the court's discretion. It is not, my Lord, what is contained in 434(1)(c), the main portion. No. Discretion of the court, discretion of the party who is making the application. If the, my Lord, creditors do not choose to go to apply under 434(1)(c) fifth proviso, then what happens? Can this court still say that, no, I will send it to...
I'd like to find out how many companies actually the BIF are revived.
This is the point.
Over a period of 28 years before it was repealed.
My lord, very few.
Very few.
But my lord, the insolvency, my lord, the reason, only reason why it's worked, my lord, is it's cleared up NPAs. There's no doubt, my lord, about that. And the reason that happens is, my lord, moment there is an admission order, my lord, and the CIRP process, as we call it, starts, my lord, instead of the management continuing to be in control, my lord, there is an independent person and the creditors come in control.
Correct.
My lord, that is the fundamental shift, my lord, in our insolvency law.
So now you know why the BIF are failed.
Yeah, my lord, it's management there, they'll remain in management. They don't want to give that up. And that happens finally when a scheme is approved. And that too scheme contemplates management continuing. Here, my lord, one of the first amendments introduced to the insolvency code was, my lord, what happened? My lord, financial creditor filed. There was no section 29A. So the existing management could offer a haircut. So, my lord, let us say 100 crores are payable. They tell an operational creditors literally had no right. Now, my lord, the banks were told, look, your one-time settlement, you would have got 40. You weren't happy. Now, before the court, I'm committing to a 50%. So, 50% of debt gets wiped out. Bank gets something. NPA is reduced. They come in. Then 29A came in, my lord, saying, my lord, that no person who is acting in concert, my lord, with the corporate debtor or its management, or is connected to the corporate debtor or its management, can, my lord, participate. Because it's not an act which was, my lord, brought into force to reward people, my lord, who have not mismanaged or, my lord, bled the company dry. That has been the biggest problem. So, my lord, if your lordships look at the figures, my lord, of, my lord, NPA resolution, my lord, it's much better. Of course, my lord, I'm not saying, my lord, that, my lord, the legislation, my lord, is absolutely fair. But we have to, my lord, the fact of the matter is, its vires has been upheld. My lord, the amendments, my lord, vires have also been upheld. My lord, my learned friend was quite right. Operational creditors left in, my lord, in the lurch, my lord, which is why now there are, my lord, mandatory requirements as to what has to be provided in, my lord, a resolution plan, apropos operational creditors, apropos workers. My lord, what is a liquidation estate? My lord, all these have, my lord, come in.
Right.
In fact, my lord, I'm actually very keen to argue this matter. Because, my lord, I think, my lord, our High Court, my lord, should lay down the law and not, my lord, just take, my lord, snippets from Supreme Court judgments in this matter. Because, my lord, there is, my lord, a principle involved, my lord, in, my lord, these legislations. And, my lord, they have to be given full effect. My lord, I want to, my lord.
Please. We'll be very happy to.
So, my lord,
Yes.
this is, my lord. And my learned friend, of course, to have him as an opponent is always a pleasure. He makes you work hard.
My lord, in fact, my lord, what I was telling your lordship, my lord, is picked up from a seminar in which, my lord, my learned friend was one of the speakers. His learned junior Ratnako Banerjee was one of the speakers, and my lord, they had severely criticized the working of this particular act. The amendment হয়েছে কিন্তু খুব কি the problem continues to remain. And my lord, with the high hopes with which the legislature, my lord, brought these acts into existence, I personally feel, subject to what my learned friend says, that really the purpose has not yet been achieved. And what I see in actual, in the litigation, in the field of litigation, I actually find that particularly the operational creditors are the sufferers. Well, as I gave your lordship the example, in 2 or 3 cases I have seen, by reason of this, the operational creditors who have put in, for example, laying of roads, construction of buildings, the operational creditors had incurred huge expenses. The matter has gone to arbitration. The arbitration is going on. And my lord, at that point of time, this corporate insolvency process is started.
Moratorium over, and then white.
That's section 14, no? Which section 14?
Arbitration stop. My lord, it's frozen. Then, my lord, the financial creditors' interests, my lord, are protected under the COC. My lord, operational creditors now statute demands that resolution plan must make certain provisions. Otherwise, initially they were getting zero. My lord, Damodar Valley Corporation, my lord, has been a huge sufferer.
Huge sufferer.
My lord, public utilities, and as it is, my lord, they are, my lord, biggest defaulters are the state and, my lord, those very units, my lord, which have gone into insolvency.
So now, my lord, it has become a screen to protect persons who are defaulters at the cost of persons who are waiting in the wings for the purpose of recovery of their dues.
Section 20. Section 20 of SICA.
Lordship will be pleased to see. In fact, my lord, this is also, my lord, considering SICA. I've seen that. Yes. Your lordship kindly comes to page 24 of this, paragraph 17. Paragraph 17 is quoting from, my lord, the judgment in Jaipur Metals, which is a 2019 judgment of the Supreme Court. Paragraph 17 is like this. Well, I am relying upon this judgment because, well, I don't have to cite other earlier judgments. This really covers all this. Paragraph 17 has been quoted. However, though the language of Rule 5.2 is plain, Rule 5.2 of the transfer rules, which I just now placed before Lordship, is plain enough, it has been argued before us that Rule 5 was substituted on 29/6/2017, as a result of which Rule 5.2 has been omitted. The effect of the omission of Rule 5.2 is not to automatically transfer all cases under Section 20 of the SICA to NCLT, as otherwise a specific rule would have to be framed transferring such cases to NCLT, as has been done in Rule 5.1. The real reason for omission of Rule 5.2 in the substituted Rule 5 is because it is necessary to state only once on the repeal of the SICA that proceedings under Section 20 of the SICA shall continue to be dealt with by the High Court. It was unnecessary to continue Rule 5.2 even after 29 June 2017, as on 15 December 2017, all pending cases under Section 20 of the SICA were to continue to be dealt with by the High Court before which such cases were pending. Since there could be no opinion by the BIFR under Section 20 of the SICA after 1/12/2016, when the SICA Act was repealed, it was unnecessary to continue Rule 5.2, as on 15/12/2016, all pending proceedings under Section 20 of the SICA were to continue with the High Court and would continue even thereafter. This is further made clear by the amendment of Section 434(1)(c), with effect from 17/8/2018, where any party to a winding up proceeding pending before a court immediately before this date may file an application for transfer of such proceedings, and the court at that stage may, by order, transfer such proceedings to NCLT. The proceedings so transferred would then be dealt with by NCLT as an application for initiation of corporate insolvency resolution process under the code. It is thus clear that under the scheme of Section 434, as amended, and Rule 5 of the 2016 transfer rules, all proceedings under Section 20 of the SICA pending before the High Court are to continue as such until a party files an application before the High Court for transfer of such proceedings post 17/8/2018. Once this is done, the High Court must transfer such proceedings to NCLT, which will then deal with such proceeding as an application for initiation of the corporate insolvency resolution process. Then, my lord, your lordship will please to come to, this is another paragraph, paragraph 9 of this judgment at page 24, running page, 655 internal page. In a significant passage, the court then went on to hold in Jaipur Metals. However, this does not end the matter. It is clear that respondent number 3 has filed a Section 7 application under the code on 11/1/2018, on which an order has been passed admitting such application by NCLT on 13/4/2018. This proceeding is an independent proceeding. My learned friend's client has also done that, which has nothing to do with the transfer pending, nothing to do with the transfer of pending winding up proceedings before the High Court. Then, my lord, the next sentence is very important. It was open for the respondent number 3 at any time, kindly note the words, before a winding up order is passed, to apply under Section 7 of the code. I submit to your lordship, that is the point I shall take before that court. That after the winding up order has been passed, my learned friend's client is not entitled to make this application and sustain the application under Section 7. Because my lord, winding up order has been passed. Kindly see this sentence. It was open for respondent number 3 at any time before a winding up order is passed to apply under Section 7 of the code. This is clear from a reading of Section 7 together with Section 238 of the code, which reads as under. Then, my lord, 238 has been provisions of this code to override the laws. The provision of this code shall have the effect, notwithstanding anything inconsistent therewith contained in any other law for the time.
Next Wednesday?
That's why I say that is not
next Wednesday.
Because this is after the winding up order.
3 o'clock next Wednesday. Every week, Wednesday, 3 o'clock at least we'll sit.
Yes. Yeah. Well, it won't take very long. But I have these are the points I have indicated to you, Lord. I shall just cite the decisions.
Mr. Mithro, learned senior counsel representing Indo Wagon Bodhai dekheni ager order ta dekheni resumes his argument but does not conclude. Paragraph, list this matter order ढुकिए दिए उठा. List this matter once again. List these matters once again on budhware date the marked 3 p.m.
Item number 1 of my lord, the supplementary list, my lord is also directed this matter to be tagged, my lord. But,
APOT 202 of 2024, which is one of the appeals we are hearing, shall be treated as heard in part by this bench.
my lord, may I file my paper book in that matter, my lord?
File your paper.
My lord,
my lord, this is my item 36, my lord.
Sir.